Lord, 2016 matter of second level.
Listing senior court is there.
Lordship, with the constant of the other side, Lordship, I beg to mention item number 2, Lordship. Matter may come up after 4 weeks.
Why?
Father of my senior has expired yesterday, Lordship.
Okay. What is your name?
DJ Sekar.
Heard Mr. G.J. Swikar.
Sir, senior name is DJ Sekar. My name is Asdas, Lordship.
Heard Mr. S. Das, learned counsel for the petitioner who prays for an adjournment on the ground that the conducting counsel for the petitioner is in bereavement. He submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment, who has no objection to the same. The prayer is therefore allowed. List this matter after 4 weeks.
I'll oblige.
May I please, Your Lordship? Lordship, I beg to mention item number 25. In this matter, some talk of compromise is going on between the parties. So I'm praying for an.
You have informed the other side.
Yes,
Heard Mr.
D. Choudhury.
D. Chaudhary, learned counsel for the petitioner who submits that there is a talk of compromise going on between the parties. And therefore, some time is prayed for so that an amicable settlement may be reached between the parties. He submits that he has informed the learned counsel for the other side regarding his prayer for adjournment. The prayer is therefore allowed. Let this matter be listed after 4 weeks.
May I please? Lord, item number 10 also same prayer. The parties are.
If I may, my
Going to be
lord,
compromised.
I'm for the petitioner, my lord.
Item number 10.
Yes, my lord. My lord, in this matter, I shall have to seek instruction. In the meantime, the matter may be fixed on 3rd, my lord. That is Monday. My lord, that is my prayer.
Lord, after 2 weeks, any date, my lord. My lord, the respondent number 5, Minal Uddin will be hearing this matter personally, your lordship. This is a land dispute, your lordship.
You said that there
He
is
is
a talk
from
of compromise.
I think so.
You don't know about anything.
My lord, the petitioner is third party to the suit. My lord, the suit is for eviction, my lord, between the plaintiffs and the defendants. Now, my lord, the learned Munsif at Sri Bhumi has passed an order for injunction over our land, which was acquisition by the government.
Heard Mr. G. Imtiaz.
I am S. Islam for respondent number
You are
1.
Mr. G. Imtiaz.
Yes,
Learned counsel for the petitioner. Also heard Mr. S. Islam. Learned counsel for respondent number 5.
1 to 5.
1 to 5.
And 9 and 10. 5 and
1 to 5 and 9 and 10.
Yes,
Who
sir.
prays for an adjournment on the ground that a talk of compromise is going on between the parties. On this, Mr. Imtiaz submits that the petitioner is a third party to the suit, in respect of which execution case is pending.
my lord, execution is not.
Third party to the suit, and he needs some time to seek instructions regarding the submissions made by learned counsel for the respondent. The prayer is allowed. Let this matter be listed.
On 3rd, my lord.
No fixed date.
My lord, would be, my lord, there's some urgency, my lord, in this matter.
Okay, on 3rd,
Deeply obliged.
3rd of November.
3rd of November.
Deeply obliged.
Masabha.
My lord, item number 31, we have instruction having given to withdraw the case. I'm on behalf of my senior BK Singh,
What is your name?
D. Pego.
Heard Miss D. Pego, learned counsel for the petitioner, submitting, heard Miss D. Pego, submitting on behalf of Mr. B.K. Singh, learned counsel for the petitioner, who submits that the petitioner may be allowed to withdraw the instant civil revision petition. Considering the submissions made by learned counsel, the prayer is allowed. This case is dismissed on withdrawal.
May I please, Lordship? Lordship, I pray for adjournment of item number 15, Lordship, 1-5.
On what ground?
Lordship, the conducting counsel, Mr. A. Huda, he is not available today, Lordship.
Heard Miss
S. Yasmin, I'm appearing.
S. Yasmin, learned counsel appearing on behalf of Mr. A. Huda, learned counsel for the petitioner, seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner.
Lordship, interim is there in this matter.
The prayer is allowed. Let this matter be listed again on 11th of November. The interim order shall continue till next day.
Much obliged.
Please, Your Lordship, I beg to mention listing of the
Listing senior court,
past regular.
listing before senior court, another court is there.
Item number 1.
Head page lot.
Sorry, yes.
This is the second time petition, my lord. The lordship's earlier order case, my lord, 27, my lord. After rejection, my lord, wife of the petition was arrested and a statement was also recorded. Subsequently, she was released. Son-in-law also examined, my lord. And in the meantime, my lord, the statement of the victim has recorded, my lord, by the police as well as 183 also. My lord, after that diary may be called for, my lord.
Heard Mr. R. Ali, learned counsel for the petitioner. Let the case diary be called for. Let also notice be issued to respondent number 2 in person to the prevailing notification of the registry in this regard. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 3 days from the date of this order, returnable on
My lord, from Rongia, my lord, 3rd of November, my lord.
notice,
We'll take step, my lord, through PP, my lord. To dates.
returnable on 8th of November, Thursday,
Eight is.
6th of November, sorry,
Yes.
6th of November. List accordingly. Should we take a bail hearing now?
My lord, I have to go to the LCR. Can it be fixed at 2, my lord?
2, at 2
2, my
we'll
lord.
take a
All,
bail.
all bail hearings, my lord,
At 2.
at 2.
If I check the record, the report hasn't come yet.
Yes, my lord, in 2 matters, my lord, that is item number 13 and item number 14, my lord. 14 is POXO matter.
It hasn't been.
Okay. 12 पर आना नहीं।
In 12, item number 12,
Post examination of victim was done, lordship.
you have some material to show that.
Lordship, not yet, lordship, but the pros exemption was held, lordship.
What is to be done?
My lord, I need to go to the PCR, my lord, because I didn't.
Okay, we'll see at 2. At 2.
Obliged, lordship.
No, otherwise in item number
Number
13 and my lord, item number 14, my lord, in both the cases, my lord, scan TCR was not, my lord, available, my lord. So it is called from us.
And for item number 13, lordship, that short date may be fixed.
Item number 13, 14, separate order. Hobo. Heard Mr. B. Chaudhary in 13. Also heard Mr. Learned, Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. K. Bashaw, learned additional public prosecutor. It appears from record that the scanned copy of the trial court record, which were requisitioned in this case, have not yet been arrived. Hence, issue reminder for the same. Let this matter be listed again on 7th of November.
My lord, obliged.
Same order for
My lord, in item 14, my lord, POXO matter, my lord, my learned friend appeared for informant. That part completed.
item 14. None has appeared for. No, if they appear lately, we
Then
will show the,
At two, my lord, because my lord.
at two we'll
At two,
take.
my lord, it will be
take
better.
Item 14 at two we'll
Yes,
take.
my lord. Others matters also at two, my lord.
Okay.
Yes. Deeply obliged.
For admission, item 3 and 4. My lord, before my learned friend in item number 3 starts, these two matters are actually not connected with each other. There was an order in item number 3 by which the item number 4 was directed to be tagged. But there is as such no connection. I think my
Malata, it was not actually item number 4, it was Malata, it has to be tagged with Malata CRP number 37 of 2023, but in fact, Malata,
Item number 4, sir.
CRP, not CRP IO. Item number 4, it is shown Malata CRP IO.
that is the confusion. Instead of CRP 37, it has come CRP IO.
What is to be done now?
It has to be Malata disconnected and the Malata CRP number 37 has to be connected with the Malata.
In item 3.
Okay.
That may be segregated now.
Item number 4.
Item 3 needs to be taken up along with CRP 37. But item 4 can be taken up, my lord. It is independent, it has come up for admission, it was directed to come up for admission.
Or lordship may fix any other date. though.
Now we'll take up item 4 later on. Item 3. Heard. Mr.
Yes,
A. Islam, learned counsel for the petitioner. Also heard Mr.
DA Kayum,
D. A. Kayum, learned counsel for respondent number
1, 2, and 3.
1, 2, and 3. It is submitted at bar that though CRP within bracket IO number 37/2023 is not connected with this CRP, with this with instant CRP IO. However, with this CRP IO stop, comma. In fact, CRP 37 number 37/27 is in fact linked with, is connected to the matter pertaining to the present CRPIO. However, by mistake, in order dated 30/5/2025, mention of CRPIO number 37/2023 was made instead of CRP number 37/2020. Stop. Considering the submissions made by learned counsel for the parties, let the CRPIO number 37/2023 be delinked, detached from the present CRPIO. Stop. The registry is directed to list this matter again after a week. After a week, along with CRP number 37/2023. List accordingly. Item number 4.
Here it was fixed for admission, my lord. On the last occasion, they had sought for an adjournment. And on their prayer, it was fixed date for admission.
Yes, what is the matter?
Matter is lordship, the petitioner, lordship, executed a Panama lordship with petitioner, respondent number 1 and 2 lordship. And
It can be disposed of today.
lordship,
Yes.
and then lordship, when they have not executed the salary lordship, the petitioner filed a title suit for passive performance lordship. And in this title suit lordship, his my petitioner's son lordship, he is the lady lordship, her son lordship, filed evidence lordship, in chief lordship,
as PW1 lord. And before lordship concluding, facing the lordship cross-examination lord. The if respondent number 3 and 4 lordship, along with the other respondents, lordship, they have lordship with the conspiracy lordship, indulge the PW1 in a criminal case lordship. That relates to murder. Now, because of that lordship, his lordship could not lordship appear before the court for facing the cross-examination lordship. And accordingly, lordship, the petitioner filed application on 3 occasions. 2 occasions they have taken time lordship, and third occasion lordship, she lordship filed the petition page 44 lordship, seeking adjournment page 44.
Yes.
Lordship, may I read that this date is fixed for cause of PWS due to severe ailment of lady plaintiff, her son, so adduced evidence in chief on affidavit that the son of the plaintiff filed evidence in chief on affidavit as PW1 on behalf of his ailing mother, that is the plaintiff of this instant suit. A criminal petition is pending before the Guwahati High Court by so filed by the aforesaid son of the plaintiff for passing of allegation under section 302 IP. The said fact was already intimated to the Honorable Court on previous date. A copy of the order passed by the Honorable High Court dated 25 appended herewith for perusal of the court. For such false case, the aforesaid son of the plaintiff, that is the PW1, presently out of station in the matter of filing of FIR before Honorable Guwahati High Court.
No, why he is out of station?
Lordship, he was there, Lordship. And that day she was there, Lordship, because the date of the criminal case was fixed, Lordship. He was consulting with his counsel, Lordship. And because of that, and because of these pendency of this investigation stage of this case, Lordship, he could not appear before fear of Lordship arrest, etc. Lordship.
You are not on bail,
No, Lordship.
PW1.
No, Lordship. And on this, when the petitioner plaintiff filed this Lordship application, Lordship, impugned order, my Lordship, page 50, Lordship. Page 50,
Page
50.
Yes.
Defendant number 3 and 4 are represented by petition number, so the plaintiff side has once again sought for an adjournment on the ground that he is present out of station for causing of an FIR against him before the Guwahati High Court.
Where this case is pending? In which court?
His Lordship, the Munsif Lordship,
Where?
Achar district.
Achar. Okay.
Peru's case record seen that on last occasions as well, plaintiff side had sought for adjournment on the same count. A copy of the Honorable High Court's order has also been enclosed along with the adjournment petition. Also seen that on last date, an ultimate opportunity opportunity had given to the plaintiff side to let PW1 face cross-examination today, but in vain. Heard both sides at length. Upon such hearing and perusal, it is felt that the criminal case of the plaintiff has no bearing on the civil suit executed by him. Hanging this suit is comes in the hope of the outcome of the criminal case filed against him will have no meaningful purpose, but would rather cause unnecessary delay. Having considered all petition number 20 is rejected, case record reveals that PW has been partly cross-examined on.
Yes, Mr. Chakravarti.
So, my lord, at least one chance, my lord.
No, why one chance when you are unable to appear?
Now, Lordship, what happened in the present situation, he surrendered. Then now he is released on bail. So
Okay.
he has now impediment.
Yes,
He is
Mr.
not taken
Chakravarti.
My lord, to start off with, your
No,
lordship,
don't. extend this
No,
matter.
I'll not extend. So far I'll just point out the facts. This criminal petition
No, he was unable to appear because he was fearing his arrest.
is
In criminal
naturally
case.
because before that, he had
Mm.
tried his luck before this honorable court in an anticipatory bail application.
But now he is ready to,
Yes.
will impose some cost.
On, your lordship will kindly. consider
Otherwise, his evidence will go on vain.
I'll just place one thing, one aspect of the matter, my lord. Here, lordship will kindly see who is the plaintiff. PW1 is not the plaintiff. And he is adducing evidence, or he seeks to adduce evidence on behalf of the plaintiff, being the son of the plaintiff, who projects herself to be an old and ailing lady, because of which she is not able to come before the docs. For 3 occasions.
No, that fact is not before us.
that-
On merit, you can demolish the PW1 during cross-examination.
That is true, my lord.
Whether his absence on that day should be condoned or not. Adjournment,
Now, insofar as the cross-examination of PW1 is concerned, now his absence on 3 occasions was on account of his inability to appear before the learned court below because of pendency of the criminal case. That is the ground, that is the sole ground that has been taken. Now, my humble contention before this honorable court is the evidence that was adduced on which the cross-examination was thought to be conducted, that was in respect of the evidence by the plaintiff side. And in the absence of PW1, the plaintiff who was all throughout present, there is no criminal case pending against the plaintiff. It is the ground, my lord, so far the evidence that has been
No,
kept by
no.
PW1.
but whom the plaintiff would examine, it is his or her choice.
The plaintiff was all throughout present. That your lordship-
Maybe.
That is the only thing, my
How
lord.
much cost
My
should
lord,
be
the
imposed?
3 days, my lord, 3 or
Suggest.
10,000.
Lordship, kindly. 5,000.
Heard Mr.
AMS
AWA.
AMS Majumdar.
AMS Majumdar, learned counsel for the petitioner. Also at Mr. D. Chakravarti, learned counsel for the respondents,
3 and 4.
number 3 and 4.
Right.
This application under Article 227 of the Constitution of India has been filed by the petitioner namely Fatima Khatun Barbhuya alias Chaudhary, impugning the order dated 25/11/2022 passed by learned Munsif number 2, Kachar Silchar in title suit number 119/2019, whereby the prayer for adjournment by the present petitioner was denied and the
Cross-examination was.
cross-examination of PW1 was closed. Stop. Learned counsel for the petitioner has submitted that the petitioner adduced the evidence of petitioner who is the plaintiff in title suit number 119/2009, adduced the evidence of her son as PW1. Stop. However, as her son has been involved in a criminal case under section 302 of the IPC, and as the PW1 had also preferred a criminal petition number, that is criminal petition number 763/2022 for quashing of the criminal case pending against him. He could not appear before the trial court on the day we fixed for his cross-examination. Stop. learned counsel for the petitioner submits that the trial court had closed the cross-examination of PW1 mainly on the ground that on an earlier occasion also, on the same ground, adjournment was sought for. He further submits that the PW1 is now ready for appearing before the trial court to face the cross-examination as he has been enlarged on bail in connection with the criminal case which was pending against him. He further submits that if the petitioner is not allowed to, he further submits that if the PW1 is not allowed to be cross-examined, the evidence, the examination in chief adduced by PW1 on affidavit may become redundant and the petitioner may be highly prejudiced because of the same. On the other hand, learned counsel for the respondents vehemently opposed the instant application filed by the petitioner on the ground that the petitioner is herself the plaintiff in title suit number 119/2009. However, instead of adducing her own evidence, she has made her son as PW1. Stop. He further submits that the trial court has rightly rejected the prayer for adjournment as repeatedly on the same ground adjournments were sought for by the petitioner. He also submits that the petitioner would suffer no prejudice as the petitioner herself may adduce evidence in support of her case. I have considered the submissions made by learned counsel for both sides. Though apparently no illegality or irregularity appears to be there in the impugn order passed by learned Munsif number 2, Silchar. However, the circumstances have changed in as much as the PW1 has been enlarged on bail in the criminal case which he was facing, and therefore presently there is no impediment on his appearing before the trial court for the cross-examination. Stop. This court is of considered opinion that as the examination in chief of PW1 has already been submitted before the trial court in form of an affidavit, it would be the ends of justice would be served if the PW1 is allowed to be cross-examined by the respondent side. Stop. Further, it is for the petitioner to choose his to select as to by adducing what evidence she would prove her contentions in the title suit number 119/2009. Stop. This court is therefore of the considered opinion that if a reasonable cost is imposed, the petitioner may be allowed to present PW1 for cross-examination before the trial court. Accordingly, stop. For reasons stated herein above, this instant criminal revision petition is allowed with a direction to the trial court to allow the PW1 to be cross-examined by the defendant side in title suit number 119/2009. When is the next date?
No, that has been stayed, the suit is stayed, so lordship will fix the date, my lord.
On when will you appear?
Next month, November, in last week of November.
On 25th of November. 25th of November, subject to payment of cost of rupees 5,000. The said cost shall be paid to the defendants in title suit number 119/2009. The payment of cost shall be a condition precedent for cross-examination of PW1. As both the parties are represented by their engaged counsel before this court, both the parties are directed to appear before the court of Munsif number 2 in title suit number 119/2009 on 25th of November, along with a certified copy of this order. And on the said date, the PW1 shall be cross-examined.
No adjournment from their side on that date.
The no further adjournment shall be granted by the trial court for cross-examination of PW1.
Deeply, from both the sides. Both the sides.
Identify.
This CRPIO is accordingly disposed.
Lordship, I'm sorry, there is interim order that may be. Interim order staying there, that may be lordship.
The consequence to the passing of aforesaid order, the interim order passed earlier shall be vacated.
I am for respondent lordship.
You are husband or wife?
Husband lordship. I have filed affidavit in opposition.
Where is the case pending?
A case lordship pending at Jorhat,
Divorce case.
divorce case.
Where the wife,
Jorhat lordship.
where wife want to
Wife
get it
wants
transferred?
tasteful lordship.
What is to be done?
Lordship, I have stated in detail Lord in my affidavit lordship, and this
You are opposing?
opposing lordships, marriage was solemnized and on a
Okay.
special marriage.
None appears. Should we dismiss the,
Lordship, I pray for lordship because this.
we'll give one more chance. None appears for the petitioner on call. Heard Mr.
Earlier also, sir, I think,
What is your name?
J. Abbas.
Heard Mr. J. Abbas, learned counsel for the respondent. Let this matter be listed again on on 6th of November.
Item 6.
Obliged. Lordship, the respondent has already withdrawn a foot lordship. So matter has been because infrastructure, so this is the order. I have a they have withdrawn the case,
Heard Mr. A. Rashid, learned counsel for the petitioner. Also heard Mr.
As the source.
S. Das, learned counsel for the respondent, who submits that the respondents have already withdrawn the title suit number 322/2024 and to that effect, he has produced the order dated 2/9/2025, passed in title suit number 322/2024, which shows that the said suit has been disposed of on withdrawal. As the subject matter of this transfer petition has been disposed of, this transfer petition has become infructuous and accordingly disposed of.
Item 7. No, previous lordship.
My lord, may I pray for a legal accommodation, my lord? My senior is Arvind another matter. And the time being. Just after.
After some time.
after-
Okay.
May I please your lordship, we will file our affidavit in opposition today itself, lordship, a short accommodation may be given.
Can it be
What is the matter?
matter relates to my love, we have approached this honorable court under Article 227 against the order passed by the presiding officer of the debt recovery tribunal. On a
That
yeah,
limitation.
delay condonation.
Limitation.
Yes, ma'am.
Yes, what is the submission to her prayer?
So it
Short
can be
accommodation.
taken up on 31st Friday, my lord. Let them file it today.
Yes, lordship.
Okay. Heard Mr. S. Khan, learned counsel for the petitioner. Also admits what is on
Yes, Yasmin.
S. Yasmin. Appearing on behalf of Mr. M. Sharma, learned counsel for the respondent, who submits that the respondent would be filing its written objection during the course of the day, and on that ground, an adjournment is sought for today. Learned counsel for the petitioner does not raise any objection to the said prayer. The prayer is accordingly allowed. Let this matter be listed on when?
31st
30.
Friday.
On 31st of October 2025. The registry is directed to reflect the name of engaged counsel for the respondents in the cause list henceforth. Please second.
Fine.
Yes.
The presentation is informed by order 21/5/2025. Caused by the learned additional procedures number 3, log in this case number 40.
Order 21.
21 through 25. Case.
What is this order?
Case number 22 to 27. Where the learned court below directed the petitioner to pay rupees 4,000 per month. As per maintenance pendant and rupees 15,000 litigation expenses.
Your husband.
Spent. I'm the petitioner. We instituted a matrimonial suit 07/23 before additional discharge.
4,000 per month.
Yes.
Why are you opposing this?
She has sufficient income. She's a government employee. She's working as a Anganwadi, this one. She get more than 12,000 per month. And another thing is there, we also paid rupees 6,000 per month in DV case number. DV case 10/2019. He's an employed and Anganwadi worker and agency of the government. And drawing a monthly salary of approximately more than 10,000. And furthermore, the respondent already availing financial benefits under protection of men's from domestic violence act. Rupees 6,000 per month. I have no sufficient income also. I have parents mother and I'm already busy with my mother. Parents are already government employee, was pensioners, but we have no any income source of income. I'm already now busy with my mother's treatment also.
What do you do? What do you do?
I'm nothing really.
You are unemployed.
Unemployed also.
At what stage the
Evidence testing. I have already paid an FSN.
mandated right in maintenance was passed in which proceeding?
DV case, DV
No, no.
108,
This impugn order has been passed in which proceeding? Divorce proceeding?
24. Section 24.
24 of,
Hindu Marriage Act.
what is it?
1955.
What
Pendant
i-
life.
No, what is the main proceeding? Pendant light interest and maintenance has been passed in which proceeding? What is the dispute going on?
Divorce in divorce petition.
Divorce, in divorce case. What stage that divorce case is pending? At what stage that divorce case is?
Evidence of already PW's evidence was almost close. Official witnesses were there.
Okay, what is your submission apart from the fact that she is employed?
Actually, 24 of Hindu Marriage Act, all it says that wherein any proceedings under this act, it appears to the court that either the wife or the husband, as the case maybe, has no independent income sufficient, but she has sufficient income for her or his support and his necessary expenses of proceedings. It may on the applications of
Who
the
filed the divorce case?
petitioner,
You,
husband.
you have adduced evidence of her income.
Yes. Already.
Any evidence is there on record?
She has
Sure.
already admitted she's a body worker. She already admitted in their WS and so in her written objection, filing the petitions, 24 petitions, she has already admitted.
No, she may be an Anganwadi worker, but that earning may not be sufficient to maintain herself.
I have two sons are also there.
I'll come to you.
What happened actually, my lord, the.
Merely because somebody is an Anganwadi worker, if her liabilities are more, that amount may not be sufficient to maintain herself and her sons. Therefore, perhaps court has granted.
Actually, I have
What?
source of income. Another thing is that my parents already deposited the huge amount in their sons, grandsons, name in the grandsons, and she was already all the documents with her, not with the petitioners.
Okay. What else is your submission? That in a DV case, rupees 6,000 has been granted as maintenance.
Yes, maintenance.
She is a Anganwadi worker, having her own income. Your parents have also
All the expenses of their educations, the children's educations,
borne
other
by-
medicals, all are bear by their parents.
Is borne- the educational expenses of the children is borne by your parents.
She was admitted in her WS also, this one.
Anything else?
Regarding this matter, I was submitted to citation regarding these petitions. 2003 Supreme Court Madras 246, in where the petitioner's husband has preferred the said OPA for divorce under section 13(1)(a)(1)(a) and 1(b) of the Hindu Marriage Act. Pending the said petition, the wife respondent Harris has filed a IA 105/1 claiming interim maintenance at the rate of rupees 2,000 per month and rupees 5,000 towards the litigation expenses under section 24 of the Hindu Marriage Act. The state application was resisted by the husband, stating that she is working in a private concern and drawing a salary of rupees 4,500 per month. It is also stated that he is earning only rupees 2,000 per month. Before the family court salary certificate of the husband dated Iman and has been marked as exhibit Iman. Based on Iman, after finding that he earnings rupees 4,070 rupees per day by working in Central Auto Payments, the family court has concluded that wife is entitled to interim maintenance at the rate of rupees 750 per month. From the date of the petition till the disposal of the OP also awarded rupees 1,500 towards the litigation expenses. The only questions to be considered in the revision is whether the wife is respondent here is made out of the case for interim maintenance in term of section 24 of the Hindu Marriage Act. Then the learned counsel for the petitioner, after drawing my attention to section 24 of the said act, the admission of the wife in the counter statement filed in the main petitions, case number Iman, would contend that since she is earning sizable income and view of the fact that the petitioner husband is getting only rupees 2,000 per month, the family court has committed an error in granting interim maintenance and litigation expenses. There is no dispute that the petition has been filed by the respondent wife claiming maintenance pendant light expense of the proceedings.
You mark the paragraph which you are relying and give that copy to me.
Two expenses is there already. At beginning.
Anything else?
Two citation is there. I was already. given.
Yes.
My lords, while going through this petition method, I could come across that the main contention which was raised by the petitioner is that this proceeding, the cross-examination or the evidence was not taken in while disposing of the section 24 petition. That was their objection. My submission is that, my lord, this section 24 proceeding is a summary procedure where evidence is not at all required. The pleadings of the parties may be relied upon. And nowadays, my lord, after the direction of the Supreme Court, assets and liabilities, my lord, affidavit is filed. Now, depending on that, my lord,
In this case, whether assets and liabilities were filed. In the 24, section 24 proceedings.
my lord, now, maybe in a DV case, it has been filed. my lord. I'm not sure, my lord. But
Then how the court computed the quantum? How much compensation is 4,000?
Per month, 15,000 litigation expenses.
15,000 for litigation expenses and 4,000 per month. In addition to the 6,000 which was paid in the DV case. But my humble submission is that, my lord, DV case for maintenance, my lord, 6,000 has been paid. And I have two sons who live with me. Their
What is his source of income? Husband's? What does he do?
husband, my lord, he is an able-bodied person, but he's not
He's an,
engaging himself in any fruitful endeavors. As such, he is not earning anything. My lord, but that does not mean, but that does not signify or
But your children are looked after by your in-laws.
my lord,
Then-
in that context, I'll have to take the instructions because I'm not sure whether that's true or not. Because my lord, 6,000,
Then take that instruction. You should know.
Another thing is there, my lord, in page number 81, we already submitted a deposition of the respondent in another case.
No. Let him take instructions. How much time will you require?
my lord, after some time.
Today itself. In the second half, we'll take it up.
Hello. To
In the second half, not at 2. After we take up fixed matters at 2, we'll take up this. You take instruction.
hello.
Appeal is mainly filed on the basis of contributed negligence of the deceased. Deceased was driving a wagoner and there is a collision with another car. And claimant has filed this case without considering the tribunal has decided the case without considering the contributed negligence. And regarding age also there is dispute. So we'll deposit 50% of the award and release into the claimant also.
Okay. Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard Mr. A.N. Iqbal, appearing for respondent number,
What? That's three claimants.
respondent number 1, 2, and 3. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant insurance company, impugning the judgment and award dated 5/10/2023 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, Guwahati, in MSC case number 2406/18, whereby a compensation amount of rupees 55 lakhs 10,703.90 paisa was awarded in favor of the claimants, respondents. Issue notice to the respondents. Since Mr. A.N. Iqbal has appeared for respondent number 1, 2, and 3, no formal notice need to be issued to the said respondents. As regards respondent number 4 and 5, the appellant shall take steps for issuance of notice by registered post
Usual process will be better. Court process usually short by usual process.
by usual process within 7 days from the date of this order, returnable after 4 weeks. This appeal is admitted. Let the records of MSC case number 2406/2018 be called for from the concerned Motor Accident Claims Tribunal in the IA. This interlocutory application under Order 41 Rule 5 of the has been filed by the applicant praying for stay of the execution of judgment and award dated 5/10/2023, passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro at Guwahati, in MSC case number 2406/2018, whereby the compensation amount of rupees, how much?
55 lakhs and all.
Compensation amount of rupees 55 lakhs
8,703.
10,703.90 was awarded in favor of the claimants responding. Learned counsel for the applicant has submitted that the present applicant has impugned the aforesaid judgment and award by preferring the connected MSC appeal number 653/2024. He further submits that said appeal has already been admitted and notices have been issued to the respondent side. He further submits that the applicant insurance company is ready to deposit 50% of the awarded amount as a condition for grant of stay of the execution of the impugned judgment and award. Since Mr. A.N. Iqbal has appeared for claimants respondent number 1, 2, and 3, and since they are the beneficiary of the impugned judgment and award, notices to respondent number 4 and 5 is waived in this interlocutory application. Considering the submissions made by learned counsel for the applicant, this interlocutory application is allowed. The execution of impugned judgment and award mentioned herein above shall remain stayed during the pendency of the connected MSC appeal number 653/2023, subject to payment of 50% of the awarded amount by the applicant before the registry of this court within a period of
6 weeks.
6 weeks from the date of this order. Stop. In the event the said amount is deposited by the present applicant the registry shall disburse the same to the claimants respondent number 1, 2, and 3.
In terms of the order by the tribunal also. Because tribunal has made some observation regarding making fixed deposit. Otherwise, Lordship is aware. Money has
Okay,
been paid
yes, yes. In terms of the order passed by the
Member MST.
learned member motor accident claims tribunal number 2 in the impugned judgment regarding the apportionment part amongst the claimants, comma, after proper verification. Stop. And proper verification and identification of the claimants. This interlocutory application is accordingly disposed of.
May I submit one thing? Fixed deposit has been given considering total award. That is why Lordship 50% of the direction. Also. Fixed deposit as 50% of the total direction.
Make line.
Otherwise, claimant will not get it.
The amount directed to be kept as fixed deposit by the motor accident claims tribunal no, the 50% of the amount directed to be kept as fixed deposit by the motor accident tribunal in the impugned judgment and award
Should be in proportion.
should be kept as fixed deposit out of the disbursed amount.
Other amount will be released by the claimant.
Remaining amount shall be released to the claimant's respondent.
Public.
Whole hearing under order 41 rule 2 item 17. I am for the appeal number 1. On the last occasion, the appellant, advocate for the appellant had withdrawn the case. Accordingly, notices was issued to the appellants by the registry office.
Item number
17.
what is the name?
Because
None has
our-
a
Our name is not shown in the. top
yes,
list,
none
so-
has appeared for the appellant. Stop. Mr.
R. Sharma.
R. Sharma, learned counsel for the respondent is present. On
Respondent number 1. Lordship.
respondent number 1 is present. On perusal of the office note dated 2/5/2025, it appears that notice sent to the appellant by registered post with AD has been shown to be duly served in the postal track consignment, which is duly delivered, duly served or duly delivered in the postal track consignment submitted by the registry, which is placed at flag A, flag T. So, however, neither the appellant has appeared in person nor any counsel has appeared, or wakalatnama has been filed on behalf of the appellant. Stop. though this appeal is liable to dismissed on for default. However, this court is inclined to grant one opportunity to the appellant. Hence, let this matter be listed again on,
Lordship, registry may be directed to show my name in the cause list.
yes. The list, Kili, listed again on 11th of November. The registry is directed to show the name of Mr.
R. Sharma.
R. Sharma
and
as
A.
en-
Hussain.
R. Sharma and A.
A.
Hussain
Hussain.
as engaged counsel for respondent number 1 in the cause list henceforth. List accordingly.
Item 18. Please, your lordship. My lord will file the substantial question of law in page 35.
Page
35. my lord.
what is the matter?
My lord, the fact of the case is that, my lord, I am the plaintiff and I've instituted a suit before the learned trial court below for paying for declaration of right title interest in respect of Schedule A and B premises. The trial court ruled in my favor in both the affairs. When it went to the appellate court court also held the concurrent finding in respect of right title interest in respect of both Schedule A and B. But then the appellate court said that in respect of Schedule B property, since the defendant is my wife, therefore I had a responsibility under section 17 of the DV Act to give her a right to right.
Respondent is your wife?
Yes, my lord.
Yes.
Defendant.
Okay.
But my lord, there have been no pleadings of DV domestic violence anywhere, either in the trial court or in the appellate court. Issue was not fixed as to whether any incident of domestic violence is there.
Where is the
And my lord,
substantial question of law?
my lord, in 35 it's starting, but I'll not be pressing for all the grounds. My lord, I'll be pressing for 7, 8.
No, this is not the way substantial questions are to be formulated.
My lord.
You read section 100.
My lord.
It says it has to be precise.
My lord, may
Yeah.
kindly have 7, page 36, ground.
No, you are not precise. What? You have to be precise.
My lord, the trial court and the appellate court specifically went beyond the pleading.
Whatsoever may be the reason, the substantial question of law has to
My
be
lord.
stated precisely in your memo of appeal.
My lord.
Otherwise, on that ground, this appeal may be rejected
My-
also.
my-
You know that.
My lord. My lord, so my lord, it has not been ordered happily. So my lord, what it ought to have been.
It has to be worded happily. That is the requirement of law.
My lord, may
You
kindly
have,
ground 9. If my lord feels that satisfied, my lord.
yes, what is that?
Whether the learned appellate court below failed to adjudicate on any instance of domestic violence committed upon the respondent number 1, defendant number 1. And my lord, number 10, whether the learned appellate court.
No,
below-
no. This is not. You frame the substantial question of law in accordance with section 100
Precisely, my lord.
precisely. Otherwise, I will reject this second
My
appeal.
lord, may kindly have a look at just once, my lord, 7. Ground
No,
7.
apparently your memo of appeal is not in terms with section 100. You have formulated how many?
My lord, I will not be pressing for all the.
Then why these are there? 16 questions, which are not substantial questions of
My
law.
lord.
You amend your memo. Otherwise, under such circumstances, what court is required to do?
Other dismiss them.
No, not dismiss. Reject the appeal. Return back the memo of appeal by giving a date.
So my lord, may kindly give me a date, I'll amend the
Memo of
substantial
appeal.
questions of law. My lord.
Heard Mr. S. Mitra, learned counsel for the appellant. Also heard Mr.
P.P. Bhotak.
P.P. Bhottakur, learned counsel for the respondents. on perusal of the memo of appeal, it appears that the said memo of appeal is not in terms of requirement of section 100 of the Code of Civil Procedure, in as much as the appellant has stated about how many?
My lord, 16.
16 proposed substantial question of law. Substantial questions of law. Stop. On bare perusal of the sum of the proposed questions, it appears that same does not appear to be substantial question of law. Section 100 of the Code of Civil Procedure mandate the appellants to state the substantial question of law precisely. Just a minute. Lastly. Mandates that the memo of appeal shall precisely state the substantial question of law involved in the appeal, which is not done in the instant case. Learned counsel for the appellant has submitted that the appellant may be given some time so that he can submit an amended memo of appeal containing the precise substantial question of law involved in this appeal. The prayer is allowed. Let this matter be listed when?
My lord, 21st of November,
21st of November.
bless me.
Item 44 from supplementary list.
May, please, my lord, kindly pass over for the timing, my lord. My lord, my senior is leg on court number 8, my lord.
Pass over for the time.
Timing item
What?
7.
Yes, Mr. Jalan.
Petitioner before your lordship with the tenant, my lord, is a landlord tenant dispute. The suit was dismissed. And in the appeal preferred by the landlord, the ground issue of finding of the bona fide requirement was reversed. Which was,
Appellate court held that it was bona fidely required by the plaintiff.
yes,
Yeah, okay.
that finding is
The case was on the ground of defaulter and
defaulter bona fide requirement as well as another issue was taken that contrary to the there's a violation of tenancy agreement. The defaulter and that violation was held to be negated in
appeal.
against yes, both by the learned trial court by as well as by the appellate court. Appellate court has concurred with the finding of the trial court. So only on the ground of this perversity that on misreading of the evidence, this finding of the bona fide requirement has been reversed. So I will take your lordship only on that issue.
Now, this this revision petition is under 227.
No, my lord, 115.
115, okay.
So my lord, the impugned judgment is at, of the appellate court starts at page 55. And the relevant issue as to the, whether it is bona fide required or not is at page 72, para 17, my lord. So since other issues are not in dispute, so I will only take a lordship to the bona fide requirement at page 72, my lord.
Just a minute.
May I read, my lord?
Yes.
Whether the suit premises bona fide requirement of plaintiff. The plaintiff submitted that the tenanted premises bona fide required by the plaintiff to accommodate the plaintiff's daughter, who is a doctor by profession and has passed her MD in pathology and intends to start a medical clinic in the suit premises with sole intention to serve people in and around her locality, as there are no other suitable room place to start a medical clinic for her daughter. Defendants have submitted that the LSP of bona fide requirement is a mala fide plea taken to justify the filing of the suit, inasmuch as the real intention of the plaintiff is to get the rent enhanced to rupees 15,000 per month, which was not agreed to by the defendants. And even though the defendants are ready to consider the demand for reasonable enhancement of rent, the plaintiff unreasonably declined to receive the rent or to scale down her demand and proceeded to file the suit by taking a false and frivolous plea of bona fide requirement to accommodate the plaintiff's daughter. The defendants stated that on earlier occasions, the plaintiff filed a title suit being suit number 279 of 1999 against one of her tenant, namely Kitabghar, taking the same alleged plea of defaulter and bona fide requirement of premises. And the said suit was decreed. And after getting the vacant position of suit premises, the plaintiff let out some portion of the premises to the defendants, and rest of the portion was converted into a garage, which goes to show that the plaintiff has no bona fide requirement of the tenanted premises, and her modus operandi to file the suit forced the tenant to agree to pay enhanced rate of rent as per her demand, and also salami or advance or quit and vacate the premises, and the same tactics is applied by filing the instant suit. The defendants further state that after refusal of the rent on being tendered by the defendants to the plaintiff, the defendants started depositing the rent in court, and in the month of September 2012, a mutual understanding was arrived at between the plaintiff and the defendants, and the defendants agreed to enhance the rent from 9,500 to 13,000. And thereafter, a draft lease agreement was sent by the plaintiff to the defendants. And since the said draft agreement was not as per the mutual understanding arrived between the plaintiff and the defendants, and in the said agreement, the plaintiff had demanded further advance of rupees 1 lakh and want to enter into the agreement with the son of the defendant number 2 and not with the defendants, which was not acceptable to the defendants. And as such, the agreement could not be signed. Had the plaintiff any actual, genuine and bona fide requirement, then the plaintiff would not have agreed to let out the premises for further period of 3 years to the son of the defendant number 2. Hence, the plea of bona fide requirement is a fake and false plea. This was the plea taken by the defendant. Now, the defendant
The son of the defendant number 2 in respect of the same suit premises.
yes, sir, it is a partnership firm and the power of attorney holder. The number 2 is the proprietor. The defendant side has supported their claim in their evidence on affidavit by exhibiting the draft lease agreement sent by the plaintiff by Exhibit C during the pendency of this suit. Defendant further exhibited certified copy of memo of title appeal number 19 of 2005 filed by the plaintiff along with the judgment passed in title suit number 279 of 1999 that is against the erstwhile tenant. PW1 in her cross-examination has admitted the version of the defendant, stating that the defendants sent one draft tenancy agreement regarding renewal of the tenancy, stating several terms and conditions of the agreement which was not agreed by her. After filing of this suit, this may be taken note of my lord. This after filing of the suit, which was not agreed by her after filing of the suit, and PW1 further admitted to having sent in return another draft lease agreement to the defendant without any signature. PW1 also admitted that Exhibit C is the draft agreement sent by her to the defendant. Now I come to the point of bona fide requirement of the plaintiff. The very admission on the part of the plaintiff to have an intention to renew the lease and the addition of the sending a draft agreement after filing of this suit makes it evident there was no bona fide requirement for which she wanted the tenanted premises.
This is the judgment of the trial court.
Yes, my lord.
Okay. Yes,
makes it evident there was no bona fide requirement for which she wanted the tenanted suit premises vacant as plaintiff wanted to continue the tenancy further. Moreover, if the requirement were bona fide, plaintiff would not have considered any renewal of the lease with the defendant. Hence, from the admission, during cross-examination and conduct of the plaintiff, the plea of bona fide requirement does not stand any ground. Considering this discussion, this instead issue is decided in negative in favor of the defendant. Now, my lord, the findings of the appellate court is at page 108 of the appellate judgment, 108, my lord, issue number 5.
yes.
May I read, my lord? Whether the
Yes.
suit premises is bona fide requirement of the plaintiff. There are 35. The requirement of the suit premises shown by the plaintiff is to accommodate the plaintiff's daughter, who is a doctor by profession and has passed her MD in pathology and intends to start medical clinic in the suit premises. The defendant challenged the said plea on grounds that the alleged plea of bona fide requirement is in fact a mala fide plea taken to justify the filing of the suit, inasmuch as the real intention of the plaintiff is to get the rent enhanced to rupees 15,000 per month, which was not agreed to by the defendants. The defendants pleaded that on an earlier occasion, the plaintiff filed title suit number 279 of 99 against one of her tenants, namely so and so. On these very grounds, and after getting vacant possession of the suit premises, the plaintiff let out some portion of the premises to the defendants, and the rest was converted to a garage. The defendants further pleaded that it is the modus operandi of the plaintiff to file suit and force the tenant to agree to pay an enhanced rate of rent as per her demand. The defendants averred in their written statement that the defendants started depositing the rent in the courts, and a mutual understanding was arrived at between the plaintiff and the defendants, and the defendants agreed to enhance the rent from 9,500 to 13,000. And thereafter, a draft lease agreement was sent by the plaintiff to the defendants, and since the draft agreement was not as per the mutual understanding arrived at between the parties, the agreement was not signed. The defendant exhibited said unsigned draft lease agreement as Exhibit C, and the plaintiff admitted that said document was sent by her to the defendant. Learned counsel of the plaintiff argued that said act cannot be construed as having no requirement of the suit room by the appellant plaintiff. The admission on part of the plaintiff no doubt goes to show that she did think over the idea of renewal of the tenancy agreement with the defendant. But this proposal was sent prior to filing of the suit, and the plea of bona fide requirement cannot be negated on this ground. This is the perverse finding, my lord. This recording of this, that the proposal was sent prior to the filing of the suit, is contrary to the deposition of the PW1. I will take the lordship the deposition of PW1 also. Now, 112, the concluding part, my lord.
Yes,
It is seen that in the instance of the defendants neither pleaded nor showed that they searched for suitable alternate accommodation to seek their place of business after receipt of notice so and so from the plaintiff, which was issued 6 months prior to termination of the lease agreement, but were unable to get one. On the other hand, the plaintiff pleaded requirement of the suit room for opening up a medical clinic for her daughter, who plus her MD and stated to have no other suitable room except the tenanted premises, except for the averment that the plaintiff has no intention to use the suit room for opening medical clinic. The defendants did not plead availability of other rooms in the building of the tenanted premises which the plaintiff can utilize for opening of medical clinic for a daughter. Thus, in light of the above judgment and also taking into consideration the pleadings and evidence, this court is of opinion that the suit room is bona fide requirement of a family member of the plaintiff. Now, my lord, the deposition, this is the contrary to the findings recorded by the now page 137 of my additional affidavit, my lord. Okay. 146 is the certified copy. May I read the type copy?
130.
137 is the type copy and 146 is the certified copy of the deposition, my lord. May I read from the 146, my lord, from the certified copy,
Yes,
from the middle?
yes.
The
Deposition of
defendants
Whose deposition is
This
this?
is position of PW1. The tenant, the landlord, my lord, Meera Bhattacharya. It's 138, my lord. Cross
Yes,
examination of PW1, page 138, and the relevant portion is page 146. May I read from the middle, my lord, the third paragraph. The defendant paid rupees so and so as per agreement. The defendant sent one draft tenancy agreement. So the my lord is
Where are you?
146, my lord. Page 146 of my additional affidavit, my lord.
Yes,
In the fourth paragraph, my lord, the defendant sent one draft tenancy agreement regarding renewal of the tenancy, stating several terms and conditions of the agreement, which was not agreed by me after filing of this present suit. So the first draft agreement was sent by the defendant tenant after filing of the suit, and that was not agreed upon by the plaintiff because that was not as per the mutually agreed terms and conditions. So in return, after filing of the suit, the plaintiff sent, my lord, I have sent a draft lease agreement to the defendant without any signature. The next portion. Firstly, the defendant sent, that was not agreed upon. So in return, the plaintiff sent. The exhibit C is the draft lease agreement sent by me. So the finding written by the learned appellate court by reversing the finding of the trial court is totally contrary and misleading of the evidence, my lord. That the agreement that though she did think about the idea of renewal of the tenancy, but that tenancy agreement, draft agreement was sent before filing of the suit. That has been recorded.
no, suppose it is filed after filing of the suit, what it implies?
My lord, at the time of the filing of the suit, okay, the landlord has pleaded that the suit is bona fide required by her. That is one thing. But upon subsequent event has to be looked into. When after filing of the suit, she has sent a draft agreement that she is agreed to renew the agreement with the defendants, not with the defendant's firm, but with the son of the defendant, proprietor of the defendant. And apart from enhancement of the rent from 9,500, mutually it was agreed that from 9,500 it will be enhanced to 13,000. But while sending the draft agreement, she has demanded 15,000, which was considered by the defendant tenant. Apart from that, she has also demanded enhanced security deposit of rupees 1 lakh. So on two grounds that could not be signed.
So is it your submission that the act of sending draft
Yes, my lord.
lease document shows
Yes,
that
my lord.
he no longer requires
Yes, my
the
lord.
suit premises?
I will take the lordship to my petition at page 110. Page 110. Firstly, 109, my lord.
Yes,
The learned appellate court has also recorded the judgment of our high court at page 109. That subsequent event, both in the event of the landlord as well as the tenant has to be taken into account. The Honorable Guwahati High Court, while deciding CRP number so and so, reiterated the view of the Supreme Court in the case of Shiv Swarup Gupta versus D. Mahesh Chanda Gupta and various other judgments of the apex court, and held that the bona fide requirement of the landlord has to be seen on the date of the petition, and the subsequent events intervening due to protected litigation will be relevant for molding the reliefs provided such events have a material impact and those rights and obligations. In other words, the question of bona fide requirement is to be envisaged as on the date of the filing of the suit, and it is the burden of the plaintiff or the landlord to prove that the said aspect of the matter. If during the pendency of the litigation, if any subsequent event occurred which disentitles the landlord to eviction on the ground of bona fide requirement, it is the burden upon the tenant to prove that such bona fide requirement of the landlord has eclipsed, as it is the tenant who seeks to disentitle the landlord a decree for eviction on subsequent event. So when the suit was presented, the plea was taken that the suit is required. But subsequently, during the pendency of the suit, after the filing of the suit, the renewal agreement was sent, and on the deposition, she has clearly admitted the landlord, yes, I have sent a draft agreement for renewal after filing of the suit. So after filing of the suit, the subsequent event has to be looked into. Although it was not signed, but she did think about of renewal. So had there been any bona fide requirement on the part of the landlord, she would not have agreed upon and sent the draft agreement.
The draft agreement with an enhanced rent.
Enhanced rate and enhanced rate
Which
was
was-
accepted. That was not materialized only on the ground that she did not want to execute the renewal agreement with the present defendant. But she want in the individual capacity of the defendant's son, the proprietor of the defendant. But the substance of the matter has to be looked into that after, at the time of the making the presentation of the suit, she has taken the plea of bona fide requirement. Had there been all through that bona fide requirement
She would not have
continued, she would
extended.
not have sent draft agreement asking for the enhanced rate, asking for the additional security deposit. So basing on this judgment of the Supreme Court and as it recorded.
Whether the defendant also asks for additional security deposit.
Yes, my lord, that is the pleaded case. That is the pleaded case. It has been recorded by the learned trial court also.
No, is there any proof of that pleading? Have you proved that the landlord asked additional security deposit from you? Is there anything to,
That exhibit C has to be looked upon. Your
apart
lordship.
from your pleading?
That exhibit C has to be looked upon. That exhibit C is not with me. But the plaint, in the plaint, yes, my lord. In the WS, I have taken that plea. Case 32, my lord.
No, my query is,
Yes,
you
my
have taken that plea.
Yes,
That
ma'am.
there was an offer for extension of the
No, that
tenancy.
was the subsequent event after the filing.
Subsequent event. And the landlord also asks for an additional security deposit. Where is that?
Yes, my in the draft, in the exhibit C, it is there, but I do not have the certified copy, only the photocopy is there, my lord.
Whether records are there?
The record is to be required. That is, it is a judgment of reversal, my lord. And it is contrary finding misreading of the evidence that is clearly visible, my lord, from the appellate court judgment in light of the deposition of the PW1 and the finding written by the learned trial court. The perusal of exhibit C will be required, my lord.
Is there any stay?
No, my lord. Immediately on, has to come from Guwahati only, Kamrup Metro. Immediately on
Yes,
receipt of the
yes.
record, that may be fixed for hearing, my lord.
Yes, what is your submission? On his,
First of all, my lord, it's a revision under 115.
we cannot go into evidence.
Yes. That is one
But
aspect
if
of
it is
it.
contrary, yes, we would make
Now-
messages, next.
Now, my friend has been trying to impress upon the honorable court that there is a misreading of evidence. But in my respectful submission is misreading is not by the honorable court, but by the petitioner. Your lordship will kindly see 137 once again. Page 137, which my learned friend has just now shown to your lordship.
Yes,
The defendant sent one draft tenancy agreement regarding renewal of the tenancy, stating several terms and conditions of the agreement, which was not agreed upon, which was not agreed by me after filing of the present suit. Now, the sequence of events, as it has been taken note of, has your lordship got 137?
yes.
Now, the defendant sent one draft tenancy agreement regarding renewal of the tenancy several times and several terms and conditions of the agreement which was not agreed by me after filing of this present suit. Now, the next line, I have sent a draft lease agreement to the defendant without any signature. Now, what had happened actually, the agreement was filed, sent to the landlord, about which the learned appellate court has also taken note of before filing of the suit. Now, after filing of the suit, since the suit was already filed, so therefore she did not accept the terms and conditions and she simply returned it back. It was not
Return the same back,
same back.
but a word A is there in,
Now, that
I have
is,
sent A. You read, I have
Yes,
sent,
that has created a confusion probably,
yes,
that I have sent a draft.
how
lease
that
agreement.
A is to be interpreted.
Yes.
A means
Now,
a separate,
now regardless of this, my lord, even if we assume that whatever sort of case is being sought to be projected by the petitioner side, question arises is whether the finding of the learned trial court is solely on the basis of this or some other facts. Now, if your lordship will kindly see the paragraph 36 at page 109 once again,
yeah,
para 36 at page 109. In the
yes,
memo of appeal, memo of revision petition.
yes,
The Honorable Guwahati High Court, while deciding CRP number so-and-so, reiterated the views of the Supreme Court in the case of so-and-so and various other judgments of the apex court, and held that bona fide requirement of the landlord has to be seen on the date of the petition. Now, if I have raised the plea of bona fide requirement, now it has to be judged on the date of the petition itself. Now, so far as the subsequent events are concerned, with regard to molding of the relief, not to disentitle the relief. If the subsequent events are in the nature of my further deprivation of rights, then relief can be molded. It is not the otherwise that if subsequent events can be taken into account to disentitle the relief. Because otherwise the meaning will be quite contrary to each other. If the bona fide requirement is to be judged on the basis of on the date of the petition, then it has to be judged on that itself. The subsequent events can mold the relief so far as the additional relief.
that is one aspect.
Yes.
Another, you read later on,
Yes, I'm reading below. The bona fide requirement of the landlord has to be seen on the date of the petition, and the subsequent events intervening due to protracted litigation will be relevant for molding the relief, provided such events have a material impact on those rights and obligations.
correct,
Now, if that, therefore, my lord, if I become, because of the subsequent events, if I become entitled to some more relief in the nature of maybe area of rent, in the nature of
that
maybe,
can be molded,
yes, then relief can be molded.
okay.
Only requirement is that if it is a case of area of rent, my lord, then subsequently I have to bring it to the notice of the honorable court that there are subsequent defaults and I have become entitled to subsequent relief. I need not bring a fresh suit for those parts. That is settled position of law. So it is only in that this
Not only, thereafter there is an
Yes.
observation.
in other
Yeah.
words, the question of bona
No,
fide,
no, if you,
in other words, the question of bona fide requirement is to be judged as on the date of filing of the suit, and it is the burden of the plaintiff or the landlord to prove the said aspect of the matter. If during the
Yes.
pendency of the litigation, if any subsequent event occurred, which disentitles the landlord to eviction on the ground of bona fide requirement, it is the burden upon the tenant to prove such bona fide requirement of the prove that such bona fide requirement of the landlord has eclipsed. Now, if this part he wants to take benefit of, then it is his burden to prove that my bona fide requirement is no longer there, or it has been eclipsed because of the conduct. Now, whether that has been
no,
he has been-
his submission is that
the
during,
sending of the
during
lease agreement.
cross-examination, he has brought out the evidence from the mouth of the,
So there is another aspect of, there is a further aspect to this, my lord, that the learned appellate court has discussed. I'm just reading that. It would be clear that for the purpose of bona fide requirement of a landlord, what is required is that it must be something more than a mere desire, but need not certainly be a compelling or absolute or dire necessity. A bona fide requirement is something in between a mere desire or wish on one hand and the compelling or other dire or absolute necessity on the other. Admittedly, the daughter of the plaintiff is a doctor by profession and has completed her MD in pathology. Plaintiff pleaded that there is no other suitable place to start a medical clinic for her daughter. The lease agreement between the parties was for a period of 3 years, and as per the lease agreement dated so-and-so, the landlady was to provide an advance notice of 6 months in case of non-renewal of the lease property. It is seen that the plaintiff, in accordance with the terms of the agreement, issued a notice on 26/3/2012, marked as Exhibit 4, to the defendants, requesting the defendants to vacate the suit room by 30th September 2012 on ground that the suit room is bona fide required for starting a medical clinic. This notice was issued some months prior to the termination of the lease agreement as agreed, and even before the plaintiff's alleged default in payment of rent by the defendants. The defendants pleaded in their written statement that the plaintiff demanded enhanced rent at rupees 15,000 per month from the month of June 2012, whereas the notice for vacating the suit premises was issued in the month of March 2012. In such a scenario, it cannot be said that the plea of bona fide requirement taken at the time of the filing of the suit was intended to pressurize the defendants to pay enhanced rent. This is the finding. And coupled with this, Miller, the further fact, paragraph 38. The Supreme Court in the case of so-and-so versus so-and-so, while reiterating its decision in Mohammed Ayub versus so-and-so, has held that one of the circumstances to be seen while appreciating the comparative hardship is to
No, no.
examine.
No, I need some clarification. When the appellate court observes that the plea of bona fide requirement was
March 2012.
was not taken in March 2012. At the time of filing of the suit was intended to pressurize the defendant to pay enhanced rent. This, the appellate court has negated. That it was,
The appellate court has negated this because of the fact that I issued the notice in
no,
March.
but this court has to see, or the appellate court ought to have seen that at the time of deciding the suit, whether there was any bona fide requirement of the suit premises by the plaintiff, and whether it has been eclipsed by subsequent events.
Yes, yes.
Now, his only plea in this revision petition is that
The bona fide requirement has eclipsed
by
because of the.
forwarding Exhibit C to the tenant, to you, he has waived or
Yes.
he has relinquished
The right of.
right of bona fide requirement and has shown his intention to extend the lease tenancy.
Now, that tenancy has never been extended. Neither it was from his side, nor it
No.
was from.
How you will address his submission that had the suit premises been bona fide required by the plaintiff, he would not have sent Exhibit C to the tenant.
No,
This is the crux. You answer this.
No, my lord, that has to be seen in my submission, my lord. That has to.
You
be
have
seen.
copy of Exhibit C with you.
Yes, madam, it is the photocopy, not the subject.
Give
Even-
এটা photocopy করো করে plaintiff কে এটা দিও. You take photocopy হবে না?
Yeah, we'll see.
We are not calling for records.
Huh?
You go through that
My
exhibit
lord, I'm just finding it out.
and answer what is your submission to his plea regarding Exhibit C.
Whether it will at all eclipse the right of the.
Yes, this is the only plea.
Yes.
If we decide this, we can decide the case.
Defendants or evidence of failure? Defendants or evidence of failure?
ইয়াতে photocopy কৰিব নোৱাৰি নেকি কোৰ্টত? ইয়াতে এটা ব্যৱস্থা ৰাখিব কোৰ্টতে কৰিব।
My lord, in that case, can it be taken up tomorrow, my lord? He is finding some difficulty
Okay,
in
we'll
tracing
take it up tomorrow. You take a copy of exhibit.
I'll find it out, my lord. Possibly it got mixed up, or I'll take it from him, my lord.
The only query is
Yes,
how you address his submission as regards exhibit C. Whether by sending an unsigned tenancy agreement to you, has he relinquished his
yes.
bona fide requirement, plea of bona fide requirement? Or can it be regarded as relinquishment of plea of bona fide requirement on your part?
Yes.
Heard Mr. G. J. Jalan, learned G. Jalan, learned counsel for the petitioner. Also heard Mr. S. Datta, learned senior counsel assisted by Mr. J. H. Soikia, learned counsel for the caveator / opposite party. The during course of hearing of this civil revision petition, a submission was made by learned counsel for the petitioner that the petitioner, while deposing as PW1 in the title suit, has stated during cross-exam in the title suit number 335/2013 has stated that he had sent a draft lease agreement to the defendant without any signatures, which is exhibited as Exhibit C after filing of the suit, after filing of the aforesaid suit for eviction. Learned counsel for the petitioner submits that the act of sending a draft lease agreement draft lease agreement to the defendant within bracket present petitioner itself shows that the plaintiff of the suit has relinquished his plea of bona fide requirement. On this, learned senior counsel for the respondent submits that some time may be granted so that he can go through the Exhibit C before he makes his counter submission in this case. The prayer is allowed. Let this matter be listed tomorrow. Tomorrow, that is on 28th of October at 2 p.m.
Like,
Order item 19.
May please your lordship.
Give me a message. Yes,
Service is complete, my lord. To be listed for hearing.
heard Miss S. Mushahari, learned counsel for the appellant. Also heard Mr. D. Mondal, learned counsel appearing for respondent number 1 to 4. The On perusal of the office note. No,
Your lordship,
it is submitted by learned counsel for the parties that appearance of parties in this appeal is complete as the name of respondent numbers 5 has been struck out from the memo of appeal on request of the appellant by order dated 9/8/2022. It also appears that records of concerned motor accident claims case has been received. This appeal is therefore ready for hearing, listed before for hearing
the last week of November, your lordship,
after 6 weeks.
your lordship, maybe fix a date, your lordship. It's simply on the,
In-
only
in
on
the
the
f-
quantum.
In the first week of December on the date to be fixed by registry.
Highly obliged.
Date, this is your lordship. Lordship, as per office note dated 23/6/25, registry has written in continuation of earlier office note, no response on behalf of R4 has been received. So lordship, registry can ascertain with the postal receipt, lordship.
When have you taken steps?
Steps were taken long time back in 22.
Then it will be difficult to take out the postal. It remains in the website for 6 months only, 6 months or 3 months.
Then
We have to
lordship-
take fresh steps.
Okay.
In the meantime, my lord, 50% may be released, my lord. It was long pending case, my lord.
You haven't,
The victims are suffering due to death of their husband and daughter, son. my lord.
Notices were served, they have not filed any objection to the stay petition, lordship. In the I also notice was sent.
stay was granted without
Without him.
any condition.
No, we were asked to take steps, lordship. We have taken step, they have not filed any objection till now. And respondent number 4 has not yet appeared. He is the owner of the vehicle.
You file a written objection that either stay may be vacated or 50% may be granted to you. Because they are not conceding. You may file a written objection.
My lord, by verbal submission, he used to grant by this.
They are not conceding.
We need respondent 4 before
Deciding this, who is respondent for? Okay,
I will file.
heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. I.A. Talukdar, learned counsel for respondent number 1, 2, and 3.
steps by usual process, lordship.
Usual process, how will you track out?
No, we won't. It goes through the district court, lordship, from the court of Munsif to that person. And the process server gives his report. Because it is in Hosai.
It appears from office note dated 23/6/2025 that notices sent to respondent number 4 have not by registered post with AD has not yet returned. So in view of above, the appellant is directed to take fresh steps for issuance of notice on respondent number 4 by usual mode within 7 days from the date of this order, returnable on 28th of November.
Yes, fine.
Highly obliged.
Highly.
May I please, your lordship? As per last order dated 22/8/2024, my lord, I was directed to take steps on respondent number 27, my lord. I had taken steps on 16/8/2024, but as per office note dated 27/6/2025, neither AD card nor unserved notices have returned for respondent number 27 till date
You take fresh steps
on 27.
by speed post. Heard Mr. H. K. Borua, learned counsel for the petitioners, Also heard Miss what is your name? N. Burman, appearing on behalf of respondent number 19, 20, and 26,
I am for 21.
as well as Mr.
Here go.
P.R. Gogoi, learned government
Government
advocate, appearing for
21 to 20.
respondent number 21 to 24. It appears that the notices sent to respondent number 27 by registered post with AD has not returned till date. Stop. Learned counsel for the petitioner has submitted that petitioner had taken steps for issuance of notice on respondent number 4 way back in the year 2024. So in view of above, the petitioner is directed to take fresh steps for issuance of notice upon respondent number 4, respondent number 27 by speed post within 7 days from the date of this order, returnable on 28th of November. This accordingly.
Your Lordship, there is an interim order.
The interim order shall continue till next.
My lord, in this item, my lord, the respondent number 1 had expired. We had filed an IA and his legal heirs had been substituted, my lord, by order dated 29/8/2025, passed in IA Civil 1475/2024. So the matter is ready as regards hearing, my lord. The LCR has also come.
Who is representing?
Expected to appear on behalf of the legal heirs
All
of
the
respondent number 1, Lordship. I will file Ukalatnama on behalf of it.
Heard Mr.
Lordship, in this case, setting aside order was abated, Lordship, but in main case, Lordship, I think there is some order, Lordship, for it. After, for Lordship, after.
Abated.
Yes, abated. After setting aside abatement, Lordship, some order, formal order may be required, Lordship.
When setting aside,
That is setting aside on 29/8 to.
which case?
IA, Lordship, that is.
Abatement,
1481.
Abatement service.
Yes, 1481.
Okay.
29/8 to.
Heard Mr. H.K. Barua, learned counsel for the appellant. Also heard Miss P. Bhattacharya, learned counsel for respondent number 1,
Legal heirs of respondent number 1, Lordship.
legal heirs of respondent number 1,
1A to 1F.
respondent number 1A to 1F. Also heard Mr. Government advocate. No government party is there. 1A to 1F. It appears that though this regular second appeal was abated on by operation of law on death of respondent number 1, however, by order passed on 29/8/2025 in IA Civil 1481/2024, the said abatement was set aside. Since the parties, that is legal heirs of deceased respondents, have already appeared and the records of trial court as well as first appellate court are also before this court, this appeal is ready for hearing. Accordingly, list this matter for hearing when? After 6 weeks. After 6 weeks.
Highly obliged, madam.
23.
My lord, here in this case, my lord, after condonation of delay, the matter has not yet been admitted, my lord. Actually, it ought to have been come in admission. It may be admitted first appeal and notice may be issued.
First appeal.
Yes,
Okay,
first appeal.
okay. Where is the delay?
Delay has already been condoned.
Heard Mr. S.K. Ghosh. This appeal,
3129. I
31257. This appeal under section 96, read with order 41, rule 1 of the Code of Civil Procedure 1908 has been preferred by the appellant, impugning the judgment and decree dated 6/4/2022 passed by London Civil Judge number 1, Kamrup Metro, entitled suit number 80/84/2016, whereby the suit of the respondent plaintiff was decreed. Stop. Though there was a delay of 80 days in preferring the instant appeal, however, by order dated 18/9/2023, passed in IA Civil number 3129/2022, the said delay was condoned. Stop. This appeal is admitted. Let the notice be issued to the respondents. How many respondents? Only one.
sole respondent.
To the respondent. The appellant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the records of title suit number 84/2016 be called for from the trial court. Registry to take steps for requisitioning the aforesaid record. List accordingly. Stay notice will go. Any execution case has been filed, then stay is not maintainable.
We have not received any notice, but there is a decree.
But stay, you are seeking stay of execution only.
Stay of the impugned judgment as well as
Impugned judgment cannot be stayed. Execution has to be stayed. We are issuing notice. Heard Mr. S. Ghosh, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant seeking stay of execution of the judgment and order passed, judgment and decree passed in title suit number 347/2015 on 6/4/2022. Stop. The said judgment and decree has been impugned by the present applicant by filing the connected regular first appeal number 40/2023. Stop. Issue notice to the opposite parties. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days, returnable on. You want a fixed date or after 4 weeks? After 4 weeks.
till
No, what is to be stayed? What should I stay? You tell me you don't know about any execution case. There is no execution case. So you find out whether execution case is there or not.
24.
May I please the lordship? So as per office note dated 18/6/25, AD card has been received from respondent number 1 and 2A. For respondent number 2E, possibly I have to seek fresh address, lordship, to return insufficient address. And for the rest of the respondents, lordship, possibly steps have to be taken, lordship, because it was taken on December of 2023.
No one has, nobody, the notice has been served.
No, they have been served on respondent number 1 and 2A, lordship.
Okay. Heard, Mr. What is your name?
D Majumdar, lordship.
Heard, Mr. D. Majumdar, learned counsel for the appellant. On perusal of the office note dated 18/6/2025, it appears that notices that AD card sent along with the note, along with the registered post with AD, along with the notices sent through sent AD cards sent along with the notices sent by registered post to respondent number 1 and 2 within bracket A have returned after the have returned with the signatures of the addresses thereon. I have perused the same. The notices issued to respondent number 1 and 2 within bracket A is therefore held to be duly served on the said respondents. As regards notice issued to respondent number 2 within bracket E, the same has returned with postal endorsement within inverted comma, insufficient address, comma, RTS. And as regards the other respondents, neither AD card nor unserved notices have been received till date. Learned counsel for the petitioner, learned counsel for the appellant has submitted that the notices were sent to the aforesaid respondent way back in the year 2022. 2020?
December of 2023.
23.
Yes, Lord.
2023. Stop. In view of above, the appellant is directed to take fresh steps for issuance of notice on all the respondents except respondent number 1 and 2 within bracket A by speed post as well as by usual mode within 7 days from the date of this order. Date of this order returnable after 4 weeks. Registry to issue reminder for requisitioning the trial court record as well as the record of the first appellate court. List this matter after 4 weeks.
Much obliged.
26.
But the records of the first appellate court has not been received. Trial court it is there.
Trial court records have been received.
Have been received. The office note reveals.
Heard Mr. A. Borkotoki, learned counsel for the appellant. Also heard Mr. A. Mubarak, learned counsel for respondent number 1, 2, and 3.
And in fact, my lord, 4 also.
1.
4 already expired, my lord, before filing this.
Oh, sorry.
substitution না লাগে লিখে দিয়েছি।
On perusal of the office note dated 3/6/2024. Sorry. It appears that records of the title suit number 87/2003 have not yet been received. Though the records of first appellate trial court record have been received. Change করে দিও। It on perusal of this office note dated so and so, it appears that though the records of title suit number 87/2003 have been received, however, records of title appeal number 2/2015 have not yet been received. Issue reminder for the records of first appellate court. Registry to take steps for requisitioning the aforesaid reports. List this matter after receipt of the first appellate court's record.
Much about.
I appear for the respondent numbers 8 to 15 and 17. The office note says that service report as regards to respondent number 1 to 4 to 7 is unserved.
None has appeared for the petitioner when the matter was called. Mr. B.J. Mukherjee appears for respondent number
8 to 15 and 17.
8 to 15 and 17. On perusal of the office note dated 19/8/2025, it appears that there is the service report in respect of respondent number 1, 2, and 4 to 7 has not been received. In view of above, you are appearing from for
8 to 15
and
17.
okay, 17. In view of the aforesaid office note, in view of the above, the petitioner is directed to take fresh steps by speed post for issuance of notice upon respondent number 1, 2, and 4 to 7 within 7 days from the date of this order, returnable after 4 weeks.
May please, your lordship. Lordship, my senior is on his legs. Lordship, may kindly pass over a matter for timing.
I am appearing for respondent 1 to
Why it
12.
has come up for orders column?
TCR has come, Right, Lordship. I think it will go for hearing. Respondent number 13 and 14, most probably they have struck off. There are 14 respondents with out of a defamation suit first step.
No, striking out order is not there. Okay, what is your name?
Yes, sir.
Heard Miss A. Sohria, learned counsel for the appellant. Also heard Mr. S.D. Purkayastha,
For respondent number 1 to 12.
learned counsel appearing for respondent number 1 to
12,
12. How many?
14 respondents.
None has appeared for respondent number 13 and 14. Though the office note dated 36/2000 25 shows that notices upon the respondents have been duly served. Appeal is yet to be admitted. Let this matter be listed for admission after 2 weeks. After 2 weeks on a date to be fixed by registry.
29. Wait, please, your lordship. Lordship, long back steps was taken and the notice was served. Lordship, kindly see the service report flag Y, lordship. Flag Y. The respondent has not yet appeared, lordship.
Your husband or wife?
I am wife, lordship. There are 3 petitioners in this case. The husband has filed a petition under guardianship act seeking a guardianship of a 4-year-old child, lordship.
Child is with you.
Yes, lordship. Well,
Then-
there is another fact, lordship. Actually, the petitioner number 1, who is the wife of the respondent, earlier she married with another person and born 2 son, lordship. After the death of her earlier husband, he got married with the respondent, lordship. The younger son is to
Okay, where do you stay? Bongaigaon.
Bongaigaon, lordship.
And where is the child? Bongaigaon.
Bongaigaon, lordship.
And case has been filed in Kokrajhar.
Another case against
No,
the
we'll fix it for admission hearing in the next week. Heard Mr. M.I. Hussain,
respondent has not appeared, lordship.
learned counsel for the petitioner. Where is the service of notice?
Lordship, may flag Y, lordship.
Putul. Miscellaneous file. No, it has returned back without service.
No, lordship, can you say, it was served on 14/11/20. The specific report is there, lordship. 14/11/2024 at 4:15 PM to the wife of the respondent. That 2-3 pages, lordship, may kindly see.
Who is Johura Khatun?
She is stated to be the wife of the respondent. It was served to the wife of the respondent. That column was there, lordship.
Unit counsel for the appellant. Though the office not dated. Office note dated 5/6/2025 mentions. No, sorry. Office note dated 28/10/2024 does not state anything about the status of notice issued to respondent, the sole respondent. However, on perusal of the report of the process server, which is available in the miscellaneous file of this case record, it appears that the notice is issued to respondent number, sole respondent was received by his wife now received by one Johura Khatun. Who is Johura Khatun? Who is stated to be the wife of the respondent. The report of the process server is supported by an affidavit. Stop. Hence, same is accepted. The notice sent to sole respondent is held to be duly served. Held to be duly served. Let this matter be listed in an admission column in the next week on a date to be fixed by registry.
Interim may be continued.
Earlier interim was granted. The interim order shall continue till next week. Civil appeal section of superintendent. ROA note to Junior Lekis. Chamber of nothing.
-44. I'm sorry, my lord. The second appeal, my lord. The appellant before your lawsuit was defended. And plaintiff filed suit for declaration of right title interest, but defendant did not contest the suit. The suit was dismissed. The plaintiff suit was dismissed, but it was ex parte. The suit was dismissed.
Dismissed or decreed?
Dismissed. Plaintiff suit was dismissed, though the plaintiff did not file any written statement. What was ex parte?
No, how plaintiff? I am not understanding. Plaintiff filed a suit for?
Declaration of right title interest and recovery of property.
Thereafter?
Thereafter, defendant did not file any written statement. It was proceeded ex parte. But that plaintiff suit was dismissed.
Okay.
Then they filed appeal. And in appeal, it was partly decreed. And against that order, my lord, I have filed this.
Okay. What is the?
My lord, this learned trial court.
In appeal, you contested? No.
Contest.
You
Then
contested.
in first appeal.
Where is the?
My lord, the substantial question of law, I have formulated here in page 5. Now plaintiff was dismissed only on the ground that mere meditation cannot confer any right.
Okay.
But in appeal also, my lord, on this, it was reversed.
Where is the substantial question?
My lord, page 5.
Page
5.
perversity.
Purpose.
Heard Mr.
And Hawk.
N. Hawk, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure has been preferred by the appellants, impugning the judgment and decree passed on 6/6/2025 and 13/6/2025 respectively by the Court of Learned Civil Justice Senior Division, Borpeta, in title appeal number 38/2023, whereby it allowed the appeal and reversed the judgment of dismissal of the suit passed on 13/10/2023 by Court of Learned Civil Justice Junior Division, number 1, Borpeta, in title suit number 174/2018. Stop. I have heard the learned counsel for the appellant. No, I have considered the submissions made by learned counsel for the appellant and have perused the materials available on record. On consideration of the submissions as well as the materials stated above, following substantial question of law is formulated in this appeal dash within inverted comma, whether the impugned judgment and decree passed by the Court of Learned Civil Justice Senior Division, Borpeta, in title appeal number 38/2023 is perverse inasmuch as it declared the right title and interest of the respondent over the suit land without any document of title or any material showing the title of the respondents over the suit land. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondent. Only one sole respondent.
Sole respondent.
Singular. Respondent by speed post within 7 days from the date of this order, returnable after 4 weeks. List accordingly.
Yes, IA by law.
Execution is there.
Execution during pendency, this appeal execution has started.
Execution has started.
Title execution case number 43 of 2025.
Heard Mr. N. Huck, learned counsel for the applicant, give that execution. This application under Order 41 Rule 5, read with Section 151 of the Code of Civil Procedure 1908, has been preferred by the applicant for stay of execution of the judgment and decree passed by the Court of Learned Civil Judge, Senior Division, Borpeta, in title appeal number 38/2023, in title execution case number 43/2025. Issue notice to the opposite parties. Since issue notice to the opposite parties, the appellant shall take steps for issuance of notice upon the opposite parties by speed post as well as by usual mode within 7 days from the date of this order, returnable on 28th of November. Stop. Since in the meanwhile, the aforesaid impugned judgment and decree has in the meanwhile, aforesaid judgment and decree has been impugned by the applicants by preferring the connected regular second appeal number 178/2025, and the said appeal has already been admitted, and since the respondent has initiated the execution of the aforesaid decree by filing the title execution case number 43/2025 before the executing court, further proceeding of execution case number 43/2025 shall remain stayed till next returnable date. Please list accordingly. Okay, 4 weeks or 28 million.
Sorry, Lordship, in connection item number 28, it is already admitted, Lordship, by order dated 17/12/2024.
Item number
28, Lordship. It is fixed for service report, respondent 2/2/12 has already filed their wakatnama, but 13 and 40 has not filed.
No, who is appearing for 28?
SD Purkasto was appearing, Lordship.
No order has already been
Yes, Lordship.
passed.
But it is already, and again, it is fixed for admission, but admission, all the matter is admitted on 17/12/2024 itself.
Then it will come for hearing.
Hearing, Lordship. TCS is available.
Then you inform Mr. Purkasta.
Lordship.
Item number 28, since the matter has been already admitted, list this matter for final hearing on the Baki Eketaki.
Item number 27, my lord. I was on next, my lord, so I did not appear. In item number 27, my lord, service is completed, my lord, on all the respondents.
Item number 27,
Service is completed, my lord. I had taken dusty, my lord, and also filed appeal. So it will go for admission, my lord, next day.
it is fixed for admission only.
Admission, my lord.
Later on, Mr. S. Das appears for the petitioner. List as early.
Right.
We have already fixed the case in the next week.
File your place.
I have only one prayer, Your Lordship. In connection with item number 14. Bail matter, Your Lordship. PCR was called for. I have found that PCR already received by the office, but it is not in the office court record, Your Lordship.
Inform the Office means office of the registry.
I verified your lordship. In fact, that already received on
The
17.
forward lock. Duta Baja Taniwab.
At 2.
We'll see whether at 2 it is available.
Obliged.
Yes, what is the status?
But status is not available here.
Yes,
Timely, my senior is coming.
let him come, we will continue. You remain.
Fine.
The status, victim has been cross-examined.
My lord,
That is what the
my lord, that,
Petitioners Council has submitted.
that is the submission from the side of the petition.
Suppose she is cross-examined,
Yes,
then whether his detention is still required.
The charge sheet. So in case bail is allowed, then he may influence those witnesses, your lordship. Your lordship will find it at page 37, the type copy, your lordship, of the charge sheet. The last paragraph, your lordship.
Then let us wait for report. Let
Yes.
the report come.
Yes.
Heard, miss, what is your name? J. Busher, learned counsel for the petitioner. Also heard Mr. K. Busher, learned additional public prosecutor, as well as Mr. Miss M. K. Brown, learned amicus curiae, appearing for respondent number 2. It appears that by order dated 15/10/2025, a report was called for from the trial court as regards the latest status of the trial court proceeding as on 17/10/2025. However, said report has not arrived. Learned counsel for the petitioner submits that it has been informed to him that the victim has already been cross-examined. However, learned amicus curiae submits that there are 2 more independent witnesses who are independent material witnesses who are yet to be examined. And she submits that the prayer for bail of the petitioner may be considered only after examination of those 2 witnesses, as there is every possibility of influencing those witnesses by the petitioner if he is released on bail at this stage. Stop. Considering submissions made by learned counsel, whether scan copy is there? It is there.
Scan copy is available, my lord, but my lord, that the cross-examination part, which is fixed, that
Okay.
is not available. My
Considering the
is-
submissions made by learned counsel for both the sides, let a reminder be issued to the trial court for sending the up-to-date status of the,
Oh, my lord, along with that, my lord, that is
Yes.
CW's.
up-to-date status of the trial, along with the deposition of victim girl as deposed by her in her cross-examination, if same has already been completed.
My-
Release this matter again when?
For November, my lord.
10th of November. 10th of November. Yes, what is this?
TCR was called for, just received. And
Records have,
TCR, my lord, just received, my lord. In the, my lord, office note, that was not available. my
You are
lord, but in the
opposing?
morning, my lord.
you're opposing the bill, objecting.
Tomorrow, my lord.
No, that is not
because,
my
lord,
question.
TCR is not available at the point of, my lord, when, my lord, in the morning, my lord. As per the office note is also available. Now, just, my lord, few minutes ago, it is, my lord, sent, my lord.
It's on tomorrow.
What is the case?
Case is there, yes. In fact, there is a lot of here. Because it is minor, but six is not as per medical, six is not the statement, but against among the familiar, their relatives here.
No, no, it may be between the trial court, the scanned copy of the trial court records have been received just in the afternoon today.
Right.
And therefore he prays for some time to go through the same before he makes his submissions in this case. The prayer is allowed. Let this matter be listed.
Tomorrow, day after tomorrow, as per your lordship convenience, my lord. Any day.
29th,
29, deeply obliged.
29th of October.
Published.
16.
May I please, your lordship?
16.
Yes. It is a charge sheeted case.
No, my lord, the investigation is going on, my lord.
Why this
Earlier, your lordship was rejected this.
rejected?
Yes, my lord. Page 20 and except 2, my lord.
What is the case?
My lord, so far the accusation against the present petitioner, my lord, that that is the petitioner is the lady FIR at page, my lord.
Now, what is the new ground?
My lord, my new ground is that the present petitioner is the lady, my lord. She's the 7 years, about 7 years, half month, my lord, pregnant, my lord. And so far the married party is concerned, your lordship has already been rejected the application, my lord. My lord, only ground is on humanitarian ground, my lord, she may be allowed to interim bail, my lord, till the delivery of the baby, your lordship. So for the married party is concerned, my lord, your lordship has already decided. I have nothing to say, my lord. But that will not change, my lord. But so for the
Marriage part means?
so for the merit of the case is concerned, my
Oh,
lord.
merit.
Merit
Okay.
of the
Okay.
your lordship order is at page.
Then
that-
how we will overcome the first rejection order?
My lord, only on humanitarian ground, my lord.
What
So
is
for
your
the
submission?
investigation part is concerned, my lord. So for the prime accused at that time, my lord, was not arrested, my lord. Now, so far my information, my lord, he has been arrested, my lord.
But you have put that girl into the room and locked from outside.
Yes.
I have had my written objection, my lord. Each and everything I have disclosed.
Uh-huh.
My lord, so far the investigation party is concerned, investigation agency has
You
already.
are getting treatment in hospital, jail hospital or not?
Hospital now. Hospital, I have annexed the copies of the medical certificate, my lord.
No,
Medical.
in custody, whether you are getting treatment or not.
No, my lord,
I-
the pre-arrest bail application.
She is not in custody, my
Oh.
lord.
She is not in custody.
My lord. Only for some period, my lord, till the delivery of the baby, my lord.
When
Sir.
is the date of delivery? Then after delivery, will you go with a newborn baby to jail?
Then, my lord,
That,
then they will come with that ground, my lord, that
so
baby.
for the
newborn
new baby is
baby
concerned, my
born.
lord, that can be managed, my lord.
How will you manage? Let me know.
To give some family members, my lord, that can be possible. my
Then
lord.
your delivery can also be managed within jail.
Or the complication may arise, my lord, in the hospital, my lord.
No, accusation is very grave,
Very grave accusation, my lord.
grave accusation.
Very grave.
Otherwise,
Single time, my lord. It's once.
My lord,
Detailed way, my lord.
Detailed,
And the
my lord.
involvement of this, my lord, that is the present accused petitioner. Already, my lord had already in earlier occasion when rejected the prayer. Categorically stated, my lord. My lord, very much is there, my lord.
And it's not that matter one time, my lord, from the accusation and from the part of the investigation, it becomes very clear, my lord.
My lord, I am on, not on the merit, my lord, of this case, my lord,
Not
but
at
only
this
on the
stage, my lord.
humanitarian ground,
The
my lord.
pre-arrest bail application, my lord.
That's why pre-arrest bail application, that's why, my lord. And so for the medical document, I have annexed the copies of the medical document. My lord, I am not asking for an absolute anticipatory bail, my lord, till the delivery of the baby.
No, but after delivery, the situation will be more.
Condition is not good, sir, my lord. So for the lady is concerned, my lord. And so far the investigation part is concerned, the civil cooperate to the investigation, my lord.
Case diary is there.
My lord, case diary receipt, my lord.
She will cooperate with the investigation. So far the main prime accused, my lord, he is already been arrested, my lord.
Not my lord, main prime accused, my lord. It is not that such submission, my lord. My lord, her involvement is very much, my lord. That is the offense initiated from the
No.
involvement of this accused petitioner, my lord. She took the.
You
my lord, that is the
surrender,
victim, my lord.
after your surrender, you may get bail. But you cannot overcome the first rejection order. Heard Mr. S.K. Jain, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor, as well as Mr.
Yes, sir.
S. Ahmed, learned counsel for the respondent number 2. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Maijan Nessa, apprehending her arrest in connection with Abhayapuri PS case number 139/2025 under section 143 within bracket 2/164 within bracket 1/3 within bracket 5 of BNS, read with section 6 of the POCSO Act 2012. Before approaching this court by filing the instant anticipatory bail application, the petitioner had, on an earlier occasion, also approached this court for seeking anticipatory bail. However, by order dated 11/9/2025, passed in AB case number 1768/2025, the prayer for anticipatory bail was rejected after perusal of the case diary and finding sufficient incriminating materials against her. Learned counsel for the petitioner has fairly submitted that on merit, the petitioner may not have any case in her favor. However, he submits that as the petitioner is a woman and presently pregnant, carrying a pregnancy of
7 months.
7 months. And in the meanwhile, the main accused has already been apprehended.
Arrested.
Stop. He submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor, Mr. K. Bosho, has produced the case diary of Abhayapuri PS case number 139/2025 and has submitted that the present petitioner is also one of the main accused in the present petitioner, though woman, is also one of the main accused in this case. And the victim girl, in her statement recorded under section 183 of BNSS, has made categorical implicating statement against her. He further submits that this being the second anticipatory bail application, the petitioner has failed to show any strong ground for consideration of her bail apart from the fact that she is carrying a pregnancy of 7 months. Mr.
Yes, sir.
S. Ahmed, learned counsel for the respondent number 2, has also vehemently opposed the grant of anticipatory bail to the petitioner in the instant case on the ground that there are sufficient incriminating material against the present petitioner. Stop. Though no, stop. I have considered the submissions made by learned counsel for both sides and have perused the case diary. Stop. Though the petitioner is a woman and carrying pregnancy of 7 months, however, the nature of accusation leveled against the petitioner are so grave, so grave that it tilts the balance against the petitioner in the instant anticipatory bail application. Apart from her pregnancy, the petitioner has not been able to show any ground as to why she may be allowed to go on bail when her first anticipatory bail application was rejected and when the nature of allegations made against her are so grave. This court is therefore reluctant to give any protection to this court, considering the incriminating materials available against the petitioner and the nature of case involved, is reluctant to give any protection to the petitioner at this stage. The prayer for anticipatory bail is therefore rejected. The petitioner will you surrender? No.
No, my lord, direction. Then I have to comply the direction, my lord.
Okay.
Oblige.
This bail application is accordingly disposed.
Oblige.
In line.
Yes.
My lord is asked to get the introduction, my lord. My lord, as per her instruction, the husband does not work now. No form of employment, but he is willingly not being involved, but he is an able-bodied person. He's not working anything.
Then you work and earn 4,500 more.
My salary in the Anganwadi center comes.
Oh, your wife.
I am the wife.
How much salary do you get?
4,500.
This is already increases by government, 10,000 to 25,000 approximately.
4,500 plus 2,000
This is
some
wrong
allowances. That has been recorded in the order also, impugn order.
Yes, wrongly statement.
And assets and liabilities, it has been submitted, ma'am. In the order, it's reflected. Assets and liabilities of both the parties have been.
Copies of assets and liabilities are there
Report.
in the record.
In the record, my lord, there has been reflected in the order. Assets and
No.
liability of the husband.
No,
is
whether copy of assets and
Yes,
liabilities
only of the husband has been annexed.
and wife. Your assets and liabilities.
Yes. In the page number 85. My assessment.
No, your assets and liabilities.
It's not on record, my lord. They have not annexed it. If required, I can get a copy or records may be called for.
No, we are not calling for record. You give a copy of assets and liabilities.
Of my assets and liabilities.
Your assets and liabilities. I'm reserving the order for orders.
Attention, another point of view there, in page number 6 of our petitions. there is an only mentions, the respondent fraudulently forced the signature of her mother-in-law and Ms. 8 lakhs from the account of her mother-in-law and also changed the phone number linked with the account. In the event of such misappropriations, the mother of the petitioner filed FIR before the police stations against which was registered as PRC 125, which was still pending before the Honorable JMHC Koliabar. Out of fear, the respondent left the matrimonial house with her 2 sons and filed an FIR against the petitioner and his father under section 498A. The case was registered PRC 149/2020 and Honorable SSM Koliabar acquitted the petitioner and his mother from this case. The respondent gave evidence in that case. The copy of the deposition and cross portion of the respondent is submitted herewith. May I attention? My lord, if you go to the page number 81. 81 are their depositions and cross examination portion in 83. My lord, may I allow to read these portions? I lost the FIR in September 2019.
Who lost the FIR?
She was filing was a 498 case. Filed a petition case, lost the FIR in 2019 for 498.
Which page you are reading? Page number?
83. Page number 83.
Yes.
I lost the FIR in September 2019. I do not remember the date. After leaving my husband's house, I lost this FIR. On 16 September 2019, I left my husband's house finally. The case which they lost against me is fixed today in the court, other court. The loan documents, Khazna receipt, land sale deed, PAN card, Aadhaar card, ATM card was submitted by me in the police station and police seized it. I am a graduate. My father-in-law helped me to getting the job in Anganwadi Center. My father-in-law work in police department and mother-in-law work in irrigation department. They both retired from service. My husband is under matric. It is not a fact that since my parents-in-law were service, sorry, my parents-in-law, and so parents-in-law were service holders and my husband was not qualified enough, I look into the financial matters of our home. It is not a fact that the ATM was completely given to me to operate. We did not have any financial problem in running the family since both my father-in-law and mother-in-law were GOV service holders. They helped me in the educational expenditures of my sons. They had financially supported me till I got the job. There are 2 loans in my name, one in Bandhan Bank and other in refinancing of the vehicles. There was one more in the Arohan, which I have made the complete payment of. Complaint of my mother-in-law is physically incapable and since cannot work in property. And next para, I had not lodged any complaint before the police when initially I was tortured by the accused. Our family got some money as our land was taken by the National Highway Authority for loan. The amount.
Why are you reading this?
Yes, there's a point, my lord. The next line is the amount was kept in my husband's account in the SBI ATM. The SBI. The ATM card of that account was also with me, which the police seized later on. From her custody, this was already ATM cards seized. And she fraudulently misrepresented or misappropriated rupees 68 lakhs from the account of his mother-in-law and parents-in-law.
No, that is an accusation that she is not admitting. That is an allegation only.
She's in cross-examination, she will do this one already admitted.
What admitted?
This one, the amount was kept in my husband's account in the SBI. The
That ATM was with her. Only that much has been admitted.
This ATM was seized by the police. This was already before it was already he admitted. See, this on the third para. The case was which was lost. Third line begin. Which was lost in my fixed today in the court. The land documents, Khazna receipt, land sale, land, PAN card, Aadhaar card, ATM card were submitted by in police stations and police seized it.
No, what it shows? It shows that ATM was with her.
She already misappropriated rupees 68 lakhs from their account.
That is your allegation. Whether it has been proved.
She was admitted, my lord. This one thing.
She has not
ATM card,
admitted.
ATM. Another thing is there also.
She has only admitted that ATM was with her.
ATM
She has not admitted that I have used that ATM to withdraw the amount. She has not admitted that.
There is another thing is there, my lord. 2, 3, 4, 5.
She denied your suggestion.
Yes, in page number 84.
She denied that suggestion of misappropriation.
Underline is there, my lord. That it is not a fact that we had one I-10 sports vehicle. 1, 2, 3, 4, 5, 6, 7, 8 lines. number 84 please numbers. The loan account of we had one item was sports vehicles which was registered in my name by my mother-in-law. The loan account of the vehicle was handled by me, my mother-in-law. They gave me money and I made the payment in this account. I had informed the finance that the vehicle in my name was not with me. Finance authority seized the vehicle and kept in the thana. This is another doing fraud with me also.
When will you submit the,
My lord, 3 weeks time maybe.
not 3, why 3 weeks?
She stays in my lord, Puliawar. She'll
Tricks is not necessary.
certified copy also there.
Then I'll pass orders. Heard Miss, what is your name?
MD Medhi.
MD Medhi, Learned Counsel for the petitioner. Also heard Mr.
K.R. Borwa.
K.R. Borwa, Learned Counsel for his. You are legal aid counsel,
Yes, ma'am.
Learned legal aid counsel appearing for respondent number 1. Hearing concluded, judgment reserved. I am reserving the order.
It's fine. See, the legal aid counsel in there also. It's not and Nagaon also.
Okay.
In Meddi case also.
My lord, that maybe establishes the fact that I'm financially very weak.
Let
It's not
me-
very actually
let-
financially.
Legal aid
It's the
counsel, my
intelligence of
lord.
this woman.
Legal aid counsel, my lord.
Yes,
she's
it's the intelligence of the woman, my lord.
availed all the services of the legal aid throughout the courts. My lord.
Okay.
Yes, more than intelligent, more.
And my lord, the arrears have not been paid, amounting to 1,80,000 or 2 lakhs, my lord.
Okay,
Still pending.
wait for your judgment.
Obliged.
Like,
May I please, your lord?
yes, item number?
30.
Yes.
Lordship, as per office note dated 16/7/2025, unserved notice has been returned back in concern with the school respondent. So I may be allowed to
Take fresh
raise
steps.
this.
Heard Mr. DJ Medhi. DJ Medhi, Learned Counsel for the petitioner. On perusal of the office note dated 16/7/2025, it appears that the notices sent to respondent by registered post with AD has returned with an endorsement, no such person in the address. In view of above, the petitioner, what will happen if you take the steps again and at the same address?
I have to find out the proper address.
On view of above, Learned Counsel for the petitioner prays for some time to find out the proper address of the respondent and take fresh steps accordingly. The prayer is allowed. Let this case be listed after 4 weeks, on which date the petitioner shall inform this court about the new address of the respondent.
Lordship, this matter has become infructuous as on date. The matter has been dismissed for default. I am for the defendant. The plaintiff did not show up for 3 consecutive days.
Suit is dismissed.
Yes, suit has been dismissed.
Heard, Mr. What is the name?
S. Afridi.
S. Afridi, Learned Counsel for the petitioner, who submits that the title suit number
346/14.
346/2025 2014, in which the impugned order was passed, has been dismissed for default. In connection of which the impugned order was passed, has been dismissed for default, and hence this civil revision petition has become infructuous. Stop. Considering the submissions made by learned counsel for the petitioner, this
My lord,
civil-
yeah, please, my lord. My lord, I may be given a liberty if the suit is restored. I may be allowed to file a fresh CRP at that point.
no, then that liberty cannot be granted. The suit is, no, the last line clear. This civil revision petition is disposed of on becoming infructuous.
43.
My senior, Mr. S.K. Mehdi, is out of station. There may be possible for the.
Heard Mr. What is your name? K.K. Medhi, learned counsel for the petitioner, who prays for an adjournment on the ground that conducting counsel for the petitioner, Mr. S.K. Medhi, is out of station. Considering the submissions made by learned counsel, the prayer is allowed.
Lordship, there is interim order.
Let this matter be listed after 2 weeks. The interim shall continue till next day.
44.
May I please, Lordship? With due respect, I am paying a short accommodation for today, Lordship. Yes, because the arguing counsel HG Bora is out of station, Lordship. She is on Arunachal, Lordship. Kindly fix it matter on Friday, Lordship.
Oh, no, why it has come up?
Chip.
In orders column, why it has? Or what this I is?
I is for condonation of delay, Lordship. For abatement and substitution, Lordship.
You are for?
I'm for respondent number 1, Lordship.
And the adjourn for the day, Lordship.
Heard Mr.
Lordship, it may be list after 7 weeks. My senior will be not available till 10 December.
No. Heard Mr.
B. Borgohai, Lordship.
B. Borgohai, learned counsel for the petitioner. Also heard Mr.
N. Das.
N. Das appearing for respondent number 1. It appears from office note dated 28. Okay. Continue. Learned counsel for the petitioner and learned counsel for the applicant / info appellant has prayed for an adjournment on the ground that conducting counsel, Miss S.G. Bora, is out of station. The prayer is allowed. Let this matter be listed after 2 weeks. 2 weeks, it will come up in orders column again.
Multiply. My lord, I am for respondent number 1 to 4. I need to file one affidavit. It is showing in the last order. I am praying for my lord 4 weeks time for that. Because for some medical emergency with the respondent.
The records have come.
Yes, my lord.
The parties have appeared. Otherwise, it is ready for hearing.
Why not let it be in orders only? I'd
you
file
will
and he
file.
might like to give reply to my affidavit also.
Heard Mr. H. Gupta, learned counsel for the appellant. Also heard Mr. P. Goswami,
Yes, my lord.
learned counsel for respondent number 124, who seeks leave of this court to file an affidavit in opposition.
My
The-
lord, leave is already there. I couldn't file
okay,
it, my
okay.
lord. Term.
Who submits that he was allowed by this court to file uh, file an affidavit in opposition.
No, my lord, it is in order 16th of July 2025, para 6. Mr. Goswami, learned counsel for respondent number 124, submits that wide order dated 24. He was asked to recalculate the compensation amount and he will calculate the same and will bring on record by filing an additional affidavit.
By filing an additional affidavit. However, he seeks some more time for doing so.
Yes,
How much time?
4 weeks, my lord.
The prayer is not objected to by the learned counsel for the appellant, hence same is allowed.
My lord, there is another prayer, my lord. Two of the engaged advocates, Mr. R. Singha and Miss S. Patwari, they have given the brief to the client. So their name to be removed, my lord. It should be there in the file. They have submitted before the registry also. Their name is showing in this cause list.
They were the earlier engaged advocate.
My lord, actually, we were all engaged because we were the lawyers at the point of time in limitation petition.
Now you are representing all the
Yes,
respondents.
I would represent, my lord. Only S. Singha and R. Singha and S. Patwari, their name to be removed, my lord. They have already given their application before the registry.
Mr. R. Goswami, learned counsel for the petitioner, submits learned counsel for respondent number 124 has submitted that the earlier engaged counsel for the respondents, namely Mr. R. Singha and S. Patwari, have returned back the brief to the respondent number 124, and to that effect, a declaration was also submitted before the registry of this court. Learned Mr. Goswami submits that as he is representing all the respondents, the name of earlier engaged counsel may not be reflected in the cause list henceforth. The prayer is allowed. List this matter accordingly after 4 weeks.
6. Lord, this case has already been admitted and service is also ready, my lord. And trial court record has also been received by the.
36.
So may I pray, it may be fixed for hearing in the month of January.
Heard Mr. S.K. Ghosh, learned counsel for the petitioner. Also heard Mr. R. Goswami, learned counsel for respondent number 1 and 2. It is submitted at bar that this case may be ready, that this case is ready for hearing, and it may be listed for hearing after 8 weeks. November, December, January. After 8 weeks, the prayer is allowed. List accordingly.
May I pray that in month of January.
Prayer is allowed. The registry is directed to place this matter in the month of January 2026 on a date to be fixed by it.
Item 47.
May I please, Your Lordship? Lordship, in this case, the respondents have already appeared. The TCL has also been received and
Ready for hearing.
I am for respondent number one.
Other respondents? 1, 2 and respondent number 2.
respondent number 2, Your Lordship, two steps on. I don't think the notice was issued upon respondent number 2, Your Lordship.
No, no, it is served.
Third one.
Heard Mr. A. Bishwas, learned counsel for the appellant. Also heard Ms. P. Bhattacharya, learned counsel for respondent number 1. On perusal of the office note dated 16/10/2025, it appears that the notice issued to respondent number 2 has been served, and as the son of the respondent number 2 has received the said notice. In view of the above, the notices is held to be duly served on respondent number 2. No one has appeared for respondent number 2. This appeal shall proceed ex parte against respondent number 2.
Your lordship, perhaps something.
In the hearing, last line Katidev. Let this matter be listed for hearing after 6 weeks.
Obliged.
Item 48.
Yes.
Appeared by filing wakalatnama. Here in this case, my lord, injunction order was passed by the trial court and appellate court, it was reversed. Case was sued for specific performance of contract.
Now this court granted status quo.
So
How many respondents are there?
actually main respondent is respondent number 1. Other 2 are pro forma.
Heard Mr. S.K. Ghosh, learned counsel. Will proceed ex parte.
Respondent number 1 appeared by filing wakalatnama.
But today he is not,
Yes, so ex parte,
or we will fix it for hearing.
yes.
Heard Mr. S.K. Ghosh, learned counsel for the petitioner. No one has appeared for respondent number 1 to 3 on call. This matter is ready for hearing.
It has not been admitted.
No, let this matter be admitted for hearing. Release this matter after 4 weeks.
Interim order.
The interim order shall continue till next day. 4 weeks for hearing.
39.
Lordship, I beg to appear for respondent number 1.
39.
39, lordship. AD has not written in respect of the other respondent, lordship.
My lord, may I just say something, my lord? Am I audible, my lord?
Yes, yes.
My lord, I have not received the copy of the petition. I made multiple requests and I have also sent an email, but I have not been served a copy of the petition, my lord. So that's one aspect, my lord. The second is, my lord, there's a issue pertaining to the maintainability of the civil revision petition itself, because this was an order passed by the learned arbitrator who was appointed by the Honorable Supreme Court of India, and the petitioner before your lordship was also a party, and they had never objected to the appointment of the arbitrator.
And the learned arbitrator also gave a finding on section 16, which the petitioner had filed, which was rejected by the learned arbitrator. And section 16 of the Arbitration and Conciliation Act, my lord, is very clear that a challenge will lie only after an award is passed. The Supreme Court, my lord, also has settled the issue in very clear terms. Therefore, there's a preliminary issue on maintainability of this petition. Of course, I have not received the copy of the petition, so, my lord, without.
You furnish the copy and we'll hear the matter on the question of maintainability on the next date. On the next date, we'll hear it.
My lord, my lord.
Heard Mr. This is item number.
39, Lord.
39.
I heard Mr. K. Jain, learned counsel for the petitioner. Also heard Mr. A. Fukon, learned counsel appearing for
Number 1, my lord. Only number 1.
respondent number 1. On perusal of the office note dated how many respondents are there?
Lordship, 14 respondents.
As regards others,
AD has not been written by Lord.
as on perusal of
My lord, in fact, the arbitration proceedings are still going on, and arbitration is also fixed today. They can actually take steps and serve them during the arbitration also. My lord, it's open to them, of course.
you make dusty service.
Lordship.
On perusal of the office note dated 23/10/2025, it appears that notices issued to other respondents have not been received back. Stop. In view of above, the petitioner is directed to take fresh steps for issuance of notice upon all respondent except respondent number 1 by speed post within 7 days from the date of this order, returnable on 28th, returnable on 27th of November.
My lord, subject to convenience, my lord, may I request for 24th or 25th, my lord, when I'm
24th of November.
deeply obliged.
Yes, the petitioner is also directed to take steps for issuance of notice upon the remaining respondents, additionally by way of dusty mode. In the event of service of notice by dusty mode, the petitioner shall submit an affidavit of compliance on the next date fixed. Stop. Learned counsel for the respondent number 1 has submitted that the respondent number 1 has not yet received the copy of revision petition along with the annexures. Learned counsel for the petitioner undertakes to furnish them the same within 2 days. Within 2 days from the date of this order. Learned counsel for the respondent number 1 has also raised a question of maintainability of the instant revision petition in view of the provisions of section 16 of the Arbitration and Conciliation Act. The question of maintainability shall be heard on the next date fixed, list accordingly.
Interim is there.
The interim order shall continue till next date.
Much obliged.
Deeply obliged.
Item number 38, ma'am. I am here for the respondent.
Item number
38. For all respondents.
38 key order actually. Later on, 38th of later on, Mr. J. Laskar appears for all the respondents. List as earlier after 4 weeks.
Obliged.
Item 40.
Yes.
We have for the
petitioner. Your Honor, this is a
How many respondents are there?
sole respondent, my lord. I am representing the sole respondent, my lord.
What is the impugn order?
My lord, here, my lord, I have small prayer, my lord. Almost 625 pages in Excel, my lord. I need to go through the records.
Okay.
So I humbly pray before this honorable court, sir, another date for admission hearing.
Admission, okay. Heard, Mr. What is your name? ML Pandya.
My lord, one interim order may be given because it is fixed for this order on 30/10. But,
No, what is the,
it was,
what you are
it was to
impugning?
refund of rupees 13 lakhs by the petitioner, to the petitioner. Petitioner means the impugns the case. The respondent means respondent is the instant petitioner of this case. She has to
13
return the
lakhs.
amount of 13 lakhs to the petitioner.
13 lakhs in which matter?
That is the impugned order. That is
Impugn order is passed in any,
it is
which case?
14/8/2025,
Divorce case?
yeah. For case number,
FC civil.
yeah, FC civil 1407.
What is this? Divorce?
My lord, divorce divorce proceeding, my lord. Joint divorce petition was filed, my lord.
Mutual.
Mutual divorce petition was filed, my lord. And the petitioner has received 13 lakhs as advance alimony from the respondent, my lord. After
You are husband?
I am the husband, my lord.
Okay.
She is the wife. So wife has received 13 lakhs as advance, in advance, as a part payment of the alimony, my lord. And thereafter, my lord, this mutual petition was filed, my lord. Thereafter, the petitioner has refused to participate in the proceeding, my lord, wants to withdraw the case, my lord.
May I submit your lordship? What had happened?
No, thereafter what happened?
Thereafter, my lord, since she doesn't want to,
They are not going for mutual.
she is not going for the mutual, so the trial court has the payment.
Directed return back of the
13 lakhs.
advance. And that they are impugning in this
Yes,
case.
my
Only one part of the story is submitting lordship.
What is the other part?
Other is that lordship, what happened, there was a divorce case was going on between the duo. But later on, while the mutual divorce case was underway, both the husband and wife entered into conjugal, they had their conjugal rights, and thereafter the husband also promised to undergo conjugal rights under the statement that he will be restoring all the marital status to her after that. And she also had to go through the miscarriage thereafter. So that agreement was violated by the husband through all these processes and false promises. So the situation arises thereafter.
My lord, is
No,
anything
no,
on
no,
the
no,
record?
just a minute.
My lord, is anything on the record?
Just a minute.
Hello.
Now, is there any hope of conciliation between us, both of you?
There is, if conciliation.
No, my lord. Already 4 numbers of FIRs were filed against me, my lord.
No.
After this order. Not 1, 2, my lord, 4 numbers of FIRs.
She will withdraw.
That is because there was no other option, because we have been misleaded multiple
No,
times.
you being officer of the court, you
Already,
see
my lord,
whether there is a possibility of amicable settlement.
my lord, already mediation was done, my lord. After this, after the mediation, my lord,
Where do you stay? Husband and wife?
we stay separately.
Where? Guwahati?
Yes, Guwahati. My lord, on the date of that impugned order, I have already submitted in my petition that if the learned court, maybe honorable court,
Then-
is to pass an
then
order for mediation of the
you-
case.
Will it be possible for both of you to appear before this court
Yes,
on next day? Let them appear. Let us try. Is there any hope or not?
in fact, my lord, what my learned friend is afraid of that, since the next date is fixed for the return, my lord.
When is the date?
30th, my lord. In fact, my lord, the trial court does not have the power. Does not have the power automatically to get the money, my lord. For that, my lord, And as per section 18 of the Family Courts Act, my lord, an execution proceeding is required to file, my lord, which is not yet filed, my lord. So there is no sense that on 30th there will be any adverse order passed.
Okay, no,
Interim may be allowed, lordship, so for the time being and a short date
heard
for conciliation.
Mr. M.L. Pandya, learned counsel for the petitioner, also heard Mr.
M.K. Sharma.
M.K. Sharma, learned counsel for the sole respondent. Learned counsel for the respondent submits that since the annexures, since the petition filed by the petitioner is supported by bulky annexures, he needs some time to go through the same. And therefore, prays that this case may be listed for admission hearing after how many days? Admission hearing. On the other hand, learned counsel for the petitioner submits that there is a hope of reaching an amicable settlement between the parties who are husband and wife in relationship. Though learned counsel for the respondent submits that he does not have any instruction as regards possibility of any amicable settlement. However, if court summons the respondent, he will appear, he is ready to appear in person before the. In view of the submissions made by learned counsel for the parties, the petitioner and respondent are directed to appear in person when will be convenient for you?
Need it, my lord.
In person on 6th of November at 1:15 PM.
2 PM.
No, in chamber,
Okay.
1:15 PM. Considering the aforesaid facts, the interim order granted earlier shall continue till next date. That is 25th of.
My lord, there is no interim
Lordship,
order.
earlier there had been no
No interim order, my
I'm
lord.
praying for.
Earlier, there was no interim order.
No interim order.
Earlier
No interim order.
Okay, then no interim order now also.
Lordship, for short.
No,
period.
they will not go for execution. Without execution.
This is my, what your lordship may record this, my lord.
This may be reflected in.
Learned counsel for the respondent submits that till date,
No execution.
the respondent has not filed any execution case against the petitioner. And in view of the development which has occurred today, he undertakes that till next date, no execution case will be filed for
Execution order.
for realization of the advance alimony which has been paid to the petitioner by the respondent. List as earlier. Kiman tarikh dilu?
6th of November.
Yes, 6th of November.
My lord, this matter may be kept part heard, my lord. Otherwise.
Yes, let this matter be listed as a part heard matter.
Much obliged.
Both of you also try to see that whether any possibility of everything can be settled.
Item 41.
May it please your lordship. My lord. So this I am, my lord. Stands for praying for continuing delay of 114 days, my lord, in preferring the connected MSC appeal.
Whether notice is complete,
That, respond
you are
number-
appearing for?
Respond number one.
Claimant,
my lord.
respondent number one.
One, my lord, they have appeared. my lord.
And for other respondents?
Steps have been taken, my lord.
Through registered post you take,
Yes, ma'am.
through speed post you take steps. You are insurance company.
My lord.
There is another insurance company.
Yes, ma'am. Yes, ma'am. The liability is upon us, my lord. Entire liability is upon us.
Heard Mr. T. Kolita, learned counsel for the applicant. Also heard Mr. A.T. Sarkar, learned counsel for respondent number
One.
Respondent number 1 / claimant. On perusal of the office note dated 22/10/2025, it appears that the notice issued to respondent number 2 has been served on the son of the respondent number 2. Whereas notice issued on the respondent number 4 has been received by an employee of the respondent number 4 insurance company. In view of the above, notices issued to respondent number 2 and 4 are held to be duly served. With regard to notice issued to respondent number 3, who is respondent number 3?
Owner of the vehicle.
The same has returned with a postal remark. Need proper address, return to sender. You take fresh steps.
Yes, sir. Because, my lord, the case is on quantum, my lord. We are challenging the quantum.
At this stage, lawsuit contribution petition may be disposed of so far that quantum is concerned, they have challenged the quantum, and lawsuit at the admission stage, again lawsuit notice may be issued. Since the major party, the main party lawsuit, respondent number
But
2,
respondent number
2 and
3,
4 already appeared, and respondent number 3 is
only
the
quantum,
Quantum,
not liability.
not like.
You are ready to pay only, you are aggrieved with the quantum.
We are
Okay.
agreeing with quantum.
Learned counsel for the petitioner, learned counsel for the applicant has submitted that the connected appeal has been preferred by the applicant as the applicant insurance company is aggrieved only with the quantum of the compensation awarded to the claimant respondent. Hence, he submits that under such circumstances, notice to respondent number 4 may be waived.
3, my lord,
And notice to respondent number 3 may be waived
in this I.
in this interlocutory application. The prayer is allowed. This interlocutory application has been filed by the applicant, that is National Insurance Company Limited, under Section 5 of the Limitation Act, praying for condoning the delay of 112 days in preferring the connected MAC appeal, whereby the applicant intends to impugn the judgment and award dated 13/8/2024 passed by the Motor Accident Claims Tribunal Darong at Mangoldoi in MAC within bracket injury case number 41/2020, stop. Learned counsel for the applicant has submitted that the grounds for approaching this court belatedly by filing the connected MAC appeal has been stated in paragraph number
My lord, 4567, serially 4567.
4 to 7 of the delay condonation application. Learned counsel for respondent number 1 claimant has submitted that the considering the grounds stated by the applicant in the aforesaid petition, the respondent number 1 does not have any objection if the delay of 112 days in referring the connected MAC appeal is condoned. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case. In view of the submissions made by learned counsel for respondent number 1, as well as in view of the grounds, as well as in view of the fact that the grounds stated in paragraph number 4 to 7 of the application for condonation of delay are found to be sufficient ground, this court is inclined to condone the delay caused by the applicant in preferring the connected appeal. Accordingly, the delay of 112 days in preferring the connected MAC appeal is hereby condoned. The registry is directed to register the connected MAC appeal and list the same for admission
Date may be fixed, Lordship.
in the next week on a date to be fixed by registry.
Date may be fixed.
Mhm.
42.
May I please have a- This appeal is for respondent expired and I have filed a substitute petition along with the delay petition for. My learned friend has.
My lord, I have received the wakalat number today for the legal aid. I'll be filing it today.
You have any objection in condonation of delay?
After filing the wakalat number, my lord.
How much delay?
There was some delay, my lord, but I
304
was the one who
days.
informed the.
My learned friend
How much delay?
304 days. 304.
Okay, let him go through your application.
In the meantime, I will file my wakalat number.
Heard Mr. S. Islam, learned counsel for the applicant. Also heard Mr.
A data.
A. Deka, learned counsel for the legal heirs of the deceased. Sole respondent.
So respond.
Deceased respondent. Who submits that he has been engaged by the legal heirs of the sole respondent to appear in this case. And he would be filing his wakalatnama within the course of the day,
So within 2 days, my lord.
within 2 days. And he submits, seeks that you have received the copies of,
Yes, ma'am. I have received the copy.
he prays for some time to respond to the interlocutory application filed by the applicant seeking condonation of delay in filing the application for abatement, application for setting aside abatement and for substitution of legal heirs. The prayer is allowed. Let this matter be listed when
2 weeks.
after 2 weeks on a date to be fixed by registry.
May I please proceed? I am for the respondent number 1. And this respondent number one.
Where is
filed-
the applicant?
Yes,
Applicant.
they've already been informed, but they didn't appear. Right.
This I is for,
I is for early hearing of the second appeal.
you have any objection?
And I am the respondent. That they have filed the
No, you have any objection for early hearing,
lordship.
for early hearing?
We have filed that application.
Oh, you have filed.
Yes, Lord.
This IA has been filed by you.
Filed by respondent number one, as I am the original plaintiff and my suit was decreed.
Okay.
And against that, they have deferred the first appeal and then now second appeal they have filed.
This interlocutory application, you are the,
I am the applicant here.
okay,
I filed this for early hearing of the
okay,
second
okay,
appeal.
okay. Therefore, they have not appeared.
That is why they want to stress this matter. But
Is there any stay?
stays in the
You were the plaintiff or defendant?
the plaintiff.
Suit was decreed or,
Suit was decreed in my favor.
and in
And
first
against-
appeal
Yeah, first appeal, first appeal preferred by them and that was dismissed.
dismissed.
And again, that concurrent finding,
You have
Um,
preferred any execution case? You have filed any
no,
execution?
execution, no, lordship.
Okay.
Because of filing of this second appeal. to it
Heard
will be-
Mr.
G. Kakoti.
G. Kakoti, learned counsel for the applicant / respondent,
Number one.
respondent number one in RSA number 170/2024. None has appeared for. To whom notices were issued?
Notice was issued to that, this appellant
Appellant is already appearing.
appearing that, they have appeared. That's it.
All have. And there are other respondents also.
Other respondent, their, other respondent lordship, but he's the other, the performer. Performer respondent.
Have they appeared in the main appeal?
No, they didn't appear. In
Wha-
even in title suit also. lordship.
What has happened in the RSA? Three, four, five struck out. Now what is to be done? They have not appeared.
They may appear, may not appear. They want to stress the matter, lordship. This is the problem, lordship.
No, but your notices are also not served.
And he's the, already LCR policy. LCR already been
No,
received.
in this
Lordship.
IA, you have issued notice to respondents. In this,
Respondent only in this IA, lordship, only the appellant is made party.
in this IA
Appellant
only
is
appellant,
only appellant is a party here. The performer respondent were not made party, lordship.
where? You are Dayamoy Deb, no,
No, I am
you are
Dharani Kumar.
Dharani Kumar Deb.
Yes, this only opposite party is that Doyamoy Dev. This is the appellant hearing, RSA.
No, but in page number 4, you have made others also party. Page number 4. So the service of notice is a
Yet to be
hindrance. Okay, let me. Out of the respondents which you have made party in this IA, who is necessary?
Necessary only that this appellant is necessary.
Appellant is respondent
Yes,
number,
Lordship. The the appellant is Doyamoy Dev, Lordship. He was the
in,
defendant number 1 in original suit.
and in this IA,
In this, and you say his respondent number 1.
on perusal of the office note dated 15/9/2025, it appears that the notice issued to respondent number 1 was served personally. Respondent number 1 within bracket appellant was served personally by the process server. Hence, notice on the respondent number 1/appellant is held to be duly served. As regards notice issued to respondent number 2, 6, it appears that they were also served personally. Notices were also issued on them. Therefore, respondent number 2 and 6 is therefore notice issued to respondent number 2 and 6 is also held to be duly served. Notice issued to respondent number 3 was refused by the son of the respondent number 3 on the ground that there was a mismatch between the name of respondent number 3 and father of respondent number 3. Okay. Learned counsel for the petitioner submits that in this case, no, as regards notice issued to respondent number 4, the process server report shows that respondent number 4 has expired. Learned counsel for the applicant has submitted that as respondent number 1 is the appellant in this case, and as the present applicant as plaintiff is the beneficiary of the decree in the trial court as well as in the first appellate court. it is the present applicant who would suffer loss, who would suffer a lot if the connected regular second appeal is not expeditiously heard. He submits that in this interlocutory application, the main respondent is respondent number 1, who is the appellant in RSA number 170/2024, who has not appeared in spite of due service of notice, as well as showing of the name of engaged counsel. In Wakalatnama, names are reflected. This is item number. No, names are not. No. I had last line to continue. This line, a line to as well as to continue. Since the connected RSA, in the connected RSA, the records of the trial court as well as first appellate court have already been received. There seems to be no difficulty in expeditiously hearing the said appeal. Accordingly, this application for expeditious hearing, this interlocutory application for expeditious hearing is disposed of with an direction that connected regular second appeal number 170/2024 shall be heard as expeditiously as possible, and let the connected regular second appeal be listed on on 7th November in orders column. In orders column, let the other side appear, because there is a death. So there will be requirement of substitution, which will automatically linger the case. So appellant shall have to take steps. So let it come in orders column on 7th of November.